And if you see there is an outsider, how can you keep quiet? An outsider is hearing what the board may be discussing, or a committee of the board may be discussing, which might include sensitive matters that should not be matters for outsiders.
In some meetings, Chair, we would have outsiders by invitation.
Sorry?
In some meetings, Chair, we would have outsiders by invitation.
Yes.
So I wouldn't know who has invited him in what capacity.
But
In fact, Chair, in the meetings that we would attend, I don't think there is any board member who questioned what his role is there. So basically, it was not only me who did not question it. No one questioned his existence at the board.
well, you see, it might be bad enough if one board member participates in discussions of SAA matters that are supposed to be discussed by the board, some of which may be sensitive matters, in the presence of an outsider without satisfying herself that there is a good reason for an outsider to be present. But once it's a number of members of the board who behave like this, then it may be worse. Because if a matter is supposed to be discussed by a board, unless there's a good reason for somebody who's not a member of the board, no one who is not a member of the board should be privy to the discussions.
Chair, as I said, people who are not members of the board would be invited from time to time to attend the board meeting.
Yes, but that doesn't answer the question. Nobody should attend board meetings who is not a board member unless there's a good reason. And every board member who sees an outsider should seek to know, why is this outsider here? What's the reason? So as to evaluate whether there's a good reason for this outsider to be in a board meeting when he or she is not a board member. You understand?
I don't understand, Chair. I don't understand, Chair.
You don't understand?
Yes.
Is your view that anybody who is not, or was your view at the time that anybody could attend a board meeting of the board of SAA even if there was no good reason, if they just wanted to listen what you were talking about?
Chair, the board members would, when necessary, invite members from outside who are not the board members to attend the board meetings.
When necessary?
Like for instance, yes, when necessary. Like for instance, at SAA Technical, we had...
No, you don't have to give examples. If you say when necessary,
yes,
I'm happy to accept that.
Yes, Chair.
But doesn't that mean that board members must be satisfied that it's necessary for this person to be here?
Yes, Chair.
Otherwise, any member of the board could object if he or she doesn't think it's necessary for a particular person to attend the board meeting, isn't it?
Yes, Chair.
Okay, Ms. Hofmeyer.
Thank you. I understood you to say you didn't know why he was attending. Is that correct?
No, I didn't say I didn't know why. I was saying as and when necessary, some outsiders would be invited to the board meeting.
No, I was asking in particular with Mr. Linnell, why was he at those board meetings and committee meetings, and your answer was you did not know. Do you recall giving that evidence?
Giving which evidence?
You testified a moment ago when I said to you, why was he at the board and committee meetings, and your answer was, I don't know.
I may not know, Chair, but the person who would invite him would know why is he in the meeting.
So at any point in those meetings that he attended, did it ever get revealed to you why it was necessary for him to be there?
Sometimes, Chair, he would make the presentations. Sometimes he would offer an opinion.
Well, Ms. Kwinana, the question is not what he did. The question is whether it was never disclosed to you why he had been invited or why he was there.
No, Chair.
No.
No, Chair.
Okay.
Did you, other than those board and committee meetings that he may have attended from time to time, have other interactions with him?
Sorry, can you repeat your question? Chair?
Other than the times that he attended those board and committee meetings, did you yourself have other interactions with him?
No.
And those board meetings, I think you indicated earlier, happen about 4 times a year. Is that right? The scheduled ones.
Yes, Chair.
And can you give me a sense, so in an average year, how many of those meetings might he have attended?
No, I wouldn't say on average how many times.
Was he always there or only sometimes?
Only sometimes.
And did you ever seek advice from him?
Yes, I did.
So you did have interactions outside of the board meetings and committee meetings?
Also in the meetings, like for instance, our understanding of Nick Linnell is that he is a legal person. So basically, if there is some legal matters, like something that when he is in a meeting, that would require like a quick legal opinion that does not require maybe a research or something. He is in a meeting and then we would say, for instance, what do you think about this?
And Ms. Kwinana, what about all the highly qualified lawyers within SAA? Why didn't you ask them those questions?
No, those would not be the structured, pre-prepared
those
questions.
Would not be what?
Those would not be pre-prepared questions. Like for instance, we know we
No,
have.
the question is, instead of having Mr. Linnell at the meetings of the board or some committees and get legal advice, quick legal advice from him, why didn't you have one of those highly qualified legal people from the legal department of SAA? That's the question.
The board meetings of SAA would not be attended by the head of legal because she was not a board member. However,
but Mr. Linnell was not a board member either.
Yes, Chair. I'm still saying she would not be invited as a board member, the head of legal.
No, she would not be invited as a board member because she's not a board member. But didn't you say people who were not board members were invited sometimes when it was necessary?
I'm still saying, Chair, the board members would attend the meeting, and then sometimes Nick Linnell would be there. And then when there is a discussion, sometimes you would say, Nick, what is your opinion about this? Not because that legal opinion was predetermined, because he is already here.
Yeah, but you said, Ms. Kwinana, he was there because he was a legal person or a lawyer or somebody with a legal background.
No, Chair.
You didn't say that?
No, I didn't say that.
So what did you say about him? Why?
I said, Chair, he would be there without me knowing why he is there. But I knew that he has a legal background. So what it means, therefore, is that if we are discussing here and there is some quick legal reference guide that is needed, considering that we know him, that he has got a legal background, we wouldn't go and ask for Ms. Fikelepi, for instance, who is the head of legal, because she is not in that meeting. However, the things that are pre-planned, and in fact, when Mr. Linnell is not there and we require the legal advice, so basically, we would know that the legal advice is required from the head of legal. But now, if for instance, in fact, it's the same thing as if we are having a
Can I summarize it for you as I understand what you want to say? Namely, Mr. Linnell would be in a board meeting or a committee meeting for whatever purpose he
Yes,
had been called to attend.
Yes,
And if in the meeting a legal question arose that board members wanted wanted an answer on, they would then ask him. And that's how you would make use of his legal background. Is that
Yes,
right?
yes, Chair.
That's what you say, you are
yes,
saying.
Chair.
Ms. Hofmeyer?
And so just so I can be clear, he wasn't there to fill the role of the lawyer.
No.
You would just ask him a quick legal
Yes,
question
yes,
every now and
sure.
then. Is that right?
That's correct.
And outside of that, because I asked you if you sought advice for him beyond those meetings, I understand your evidence to be you didn't.
No, Chair.
Right. Do you know whether Mr. Nick Linnell was paid for his services attending those meetings and giving that quick legal advice?
I don't know, Chair.
You don't know. You don't remember having received invoices from him regularly in 2015 and 2016?
No, Chair.
You don't. And if,
I'm sorry, Ms. Hofmeyer. From what you have said, it appears that your understanding is that it was not Mr. Linnell's legal background that the board really needed him for.
Yes, Chair.
The legal background just came in handy whenever there were questions and he was at the meeting.
Yes, Chair.
What was your understanding of what actually the board needed him for in these meetings? Did you have an understanding of that or did you not have? What services, what skills did the board need him at these meetings for?
The board did not need a skill from him, Chair, because there was the head of legal.
Yes.
But as you correctly put it, if he is there and we need quick legal advice, what do you think, Nick? Then that's that type of thing.
You say the board didn't need any particular skills from him.
No, Chair.
But then the question arises, why was he brought in? Are you able to throw light on that?
No, Chair. I'm not the one
You're
who
not
brought
able
him
to
in.
throw light. Ms. Hofmeyer?
did you gain an understanding of who did invite him?
No, Chair.
And you never asked?
No, Chair.
You said he came to some meetings, not all. Are you able to say most meetings, or you just say some?
Some meetings, Chair.
Some meetings. Would you be able to say, when you say some, is it something like 2, 3, 4, maybe 5 meetings over a certain period, or is that something you can't remember?
No, Chair. I can't remember.
Okay, but it certainly was not once.
Yes, Chair.
Yes, okay.
And was it more than 5?
I really do not know, Chair.
Can you set an outer limit from what you can recall, not more than 10 or something like that to help us?
No, Chair, I can't answer that question. I really do not know. Because I may say he was in a meeting and maybe I found him in the passage, something like that. So basically, I just wouldn't know.
Okay.
Thank you. But you did not engage him beyond his presence at meetings. I have that evidence correct. Is that right?
Yes, Chair.
Do you know if any of the other board members engaged him beyond the confines of meetings?
I don't think so, Chair.
And then I was asking you, are you aware that he was paid for his services to SAA?
I'm not aware, Chair.
And do you have a recollection of what types of presentations he made to the board at sometimes? Because you did say he made some presentations.
No, I wouldn't remember. Those would be like ad hoc presentations, Chair.
Yes, okay, all right.
And I have your evidence to be you didn't really need him for anything there. So can I understand your attitude then to him being paid? Would it surprise you then to learn that he was paid by SAA?
Chair, of course, I would expect a person to be paid for services rendered. He may have been rendering some services. I don't know.
No, indeed. I'm talking about the ones that you do know about. You said he attended some board meetings and some committee meetings. Your evidence a few moments ago was that we did not need him for anything. And what if I told you he was being paid for that for which you didn't need him? Would that concern you?
But Chair, what if the other members of the board needed him?
I think when Ms. Hofmeyer talked about you not needing him based on your evidence, her understanding was, and that would be my understanding, was that you were talking about the board, that in your view, the board did not need him, that you were not talking about you yourself personally, that you didn't need him, because obviously he was not there for you, he was there for the board. So the understanding was that your evidence was, in effect, that the board did not actually need any services from him. That's why Ms. Hofmeyer is asking whether it would concern you if somebody was being paid for being at meetings when actually the board actually did not need him to be there.
Much as I did not feel the need for him to be there, I did not sit in all committees, Chair. I only sat in the audit committee. So the other committees may see the need for him to be there.
But in the risk and audit committees, of which you were the chairperson, isn't it?
Yes.
He could only come there if you approve that he should come there, isn't it?
Yes,
as the
Chair.
chairperson.
Yes, Chair. And he never attended the audit committee meeting.
Yes. Did he ever attend meetings of the Audit and Risk Committee with your approval?
No, Chair.
No, okay.
Sorry, and then I do just need to return to my question, because the question is focused in on the board meetings that you were present at and he was present at. Let's forget the other meetings. What I'm interested in, Ms. Kwinana, is your response to the following. Your evidence is that he attended some of those meetings and the board did not need him for anything at those meetings. And then I say to you, well, if that is so, would it concern you to learn that he was being paid to be at board meetings where he was not needed?
Chair, I don't know. I cannot say with certainty that he was not needed.
Sorry.
Maybe the other
Look
board
this side,
members-
Ms. Kwinana. Just repeat your answer.
Chair, I was still saying, I cannot say the other board members did not need him. Maybe the other board members did need him, because also SAA does allow for some extra specialized resource if it is going to add value to the company. It does allow for that, like for instance, the outsourcing. But what I am saying, as for me, I did not see the need for him to, I did not see him adding value in my activities as the board member. However, I am not saying other board members do not see the value, because the other board member may come here and say, Nick added a lot of value to the board.
Yes, no, we want you to answer based on your observations and your experiences and what was discussed. Was there any meeting of the board where there was a discussion about what value he was adding, or why, whether anybody needed him?
No, Chair.
No.
No.
Ms. Hoffman?
And if he was being used for his services, because there was a sense from some members of the board that his services would be useful to the company, then I assume they would need to go through the proper processes to procure those services, wouldn't they?
Yes, Chair.
Yes. So a procurement process should be followed in accordance with the Constitution and the PFMA before somebody whose services are required for SAA. Is that correct?
Yes, Chair.
And are you aware of any procurement process ever having been followed before Mr. Nick Linnell appeared at board meetings?
I don't know, Chair. The procurement process is done at operations. The only time it comes to the board is when the delegation requires it to happen.
So the short answer is you are not aware, but you
I'm
are
not.
saying, as far as you are concerned, that does not necessarily mean
That
no
procurement
processes
processes
were
were not
followed, but
followed. They may
you are
have
not
been
aware.
followed.
Yeah.
Yes,
okay.
Chair.
So the board generally doesn't involve itself in those procurement processes. Is that correct?
Yes, Chair.
And so a board member going to a meeting with suppliers about finalizing contracts would be unusual. Is that correct?
Yes, Chair.
And if a board member went on her own and met with suppliers to SAA without any member of management, that would also be unusual, would it not?
Yes, Chair.
Ms. Kwinana, when did you resign from SAA?
23rd of August, 2016.
Your voice is low, Ms. Kwinana. Just repeat that answer and face this side.
23rd of August, 2016.
Okay.
And why did you resign?
I think Minister Gordon, I think there was issue with funding where basically Minister Gordon wanted the new board members.
I'm not sure I understand that. Could you just elaborate? Minister Gordon had an issue with funding and wanted new board members. Is that right?
Yes, Chair.
So did he communicate that to you?
I don't remember, man. I think what you need to do, I did write the resignation letter, and my reason for resigning are stated in that letter, and nothing has changed.
Right. So do you remember those reasons now, or would you like to go to the letter?
I would like to go to the letter.
Right. You'll find that in your bundle, which is DD 33, at tab 10. So, Chair, this will be Exhibit DD 33.10, if we may enter it into the record.
33.10.
It's under tab 10, and it's at page 84. So if you go just to page 84, that might be easier.
You want me to read it, Chair?
I don't think we need to read it in. You said you maybe take a moment so it can refresh your memory about why you resigned, and then you can tell us in your own words why you resigned.
Oh, yes, Chair. I remember.
Yes.
Thank you. So what were your reasons for resigning?
The main reason basically was that the National Treasury was not issuing the guarantee, which resulted in the audited financial statements not to be finalized. And so basically my understanding was that the minister wants the board that he himself has selected.
But how did you know he wouldn't select you?
If he would select me, at least he would start from scratch, and he would start from scratch after I have resigned. And then when he appoints new board members, if he wants to select me, then he would do so. So I think it was going to be easy for me to resign, because if he wanted me, he would still select me.
So let me just understand this, because I have to say I did read your letter of resignation a few times, and there were parts of it that just were not clear to me. So I'd like to give you an opportunity to assist me. I understand you to be saying that you had some understanding that the government guarantee that SAA needed was not going to be forthcoming unless the current board resigned. Is that right?
Yes, Chair.
Right. Now, imagine, oh, sorry, let me ask first. How was that communicated to you, that issue?
Chair, you know, no one doesn't see that there are some disagreements between the shareholder, for instance, and the chairperson, or maybe and the board, or chairperson of the board. Everybody can see if there are cracks.
And so your understanding was he wasn't issuing the guarantee until this board resigned. Is that correct?
Yes, Chair. That was my thinking.
And imagine the whole board had resigned. What then would have happened?
Then the shareholder would appoint new board.
Do you know that it's quite an important principle of corporate governance that there be continuity on boards at any company, but particularly state-owned enterprises?
Yes, Chair.
So if the whole board had resigned in order to release this government guarantee, there would be no continuity on that board, would there?
Yes, Chair.
Did that concern you at all, that you might be putting this letter of resignation in with all your fellow board members?
Chair, one would have to weigh the options and look at what would be best for the company. Would it be best for me to resign so that the minister can appoint the new people? Or would I sit here and then the guarantee is not forthcoming, and then the company goes into liquidation? So I had to weigh the options.
Ms. Kwinana, I've just been told if you could just try and raise your voice a bit more, and just do remember, if you could, to direct your answers to the chair. You mentioned in particular that you were all aware at the time of some, let's call it, conflict between Minister Gordhan and the then chairperson of SAA. Is that correct?
Yes, Chair.
Do you know when Minister Gordhan made the next appointment for the new board?
No, Chair.
So would it surprise you to learn he did it just more than a week after you resigned?
No, I was not aware.
And would it surprise you to learn that he kept on Ms. Mieni?
I know that.
So what happened to that conflict that you were aware of and that underscored your reason for resignation?
Maybe I was the undesirable element.
Was that communicated to you? Because I understood you to say that what was at issue at the time was Minister Gordhan and the chairperson, Ms. Mieni. Did you receive indications that you were undesirable on the board?
No, Chair.
So it wasn't that. Did you have any other reason for resigning, Ms. Kwinana?
Everything, all the reasons are in this letter, Chair.
And none over and above what's in the letter?
No, Chair.
Now, I take it that the Minister Gordhan, never told you that the guarantee would not be provided until the board had resigned. Did not say that himself to you, or did he?
I can't remember, Chair, but it was a well-known fact that
You can't
basically-
remember whether he told you.
Yes, Chair.
He might have.
Yes.
Okay. If he did, would this have been in a board meeting of SAA, or would it have been a separate meeting or encounter with him between the two of you?
No, definitely not between the two of us. Definitely not at SAA. Maybe at Department of Finance.
Maybe at the Department of Finance.
Yes, Chair.
But
I'm not sure. But it was a well-known thing.
Is it something that was conveyed to you as a board member or to the board members by somebody such as the chairperson of the board, saying this is the position of the minister? Or can you not remember?
I don't remember, Chair, how it was communicated. But as I said, everybody knew about it.
And you can't remember whether it was communicated in writing by way of a letter or email?
No, definitely it definitely was not in writing, Chair.
Okay.
Thank you. And Ms. Kwinana, are you aware of the evidence of Mr. Motibe, the previous PwC auditor before the commission?
Yes, Chair.
So you did look at that evidence as well, is that correct?
Yes, Chair.
Now, Mr. Motibe is somebody you would have had quite a few interactions with, being the chair of audit and risk, while PwC and Konki were auditing SAA, is that correct?
Yes, Chair.
Did you regard him as a good auditor?
Yes, Chair.
Did you trust his judgment?
Yes, Chair.
And did you interact quite frequently with him in that role?
Not frequently, because remember that the external auditors come once a year. So I wouldn't say frequently.
But you would engage him at audit and risk committee meetings that they attended, is that right?
Yes, Chair.
And how many of those are there a year?
4.
Thank you. I would just like to get a few background issues about obligations of board members out of the way with you. Is it your understanding that board members of SOEs are required to comply with obligations under the PFMA?
Yes, Chair.
And are you aware of the obligations that the PFMA places on board members?
Yes, Chair.
And can I ask one question? In Ms. Mamela's evidence, I think it was in February this year, she said that it was against procurement rules for a bidder, while a tender is still open, to meet with somebody who's a decision maker from the state-owned entity concerned. Do you agree with her on that?
Not entirely, Chair. The reason why I'm saying not entirely is that you would meet with the person not knowing that there's a tender going on, and also even that person not knowing that there's a tender going on. And if you are not involved in any tender, you would really not know that there is a tender now that is going on.
But if you did know that a tender was going on, then would it be against procurement rules?
It would also depend, what is your involvement in that tender?
No, she believed that if you just met with somebody, so you've got a tender that's open, and you've got a decision maker in the state-owned entity who's gone out and tender, and that person meets with somebody who's a bidder. She said that would be against procurement rules. Do you accept that?
No, I don't accept it. It would also depend, as I said, it would depend on the involvement of that person in that tender.
Why?
Like, for instance, you can't expect a person, like you meet a person in town and you don't know what is happening in the tendering process, but it happens that the person is working in this place where there is a tender going on. No, it can't be taken like that.
So if you do know that...
I do not know what Ms. Hofmeyer is saying was said by Mrs. Memela.
I'm sorry, Ms. Mbanjo, I haven't said you may speak. What do you want to talk about?
Oh, I must apologize, Chair, sorry.
Yes.
What I wanted, Chair, is if Ms. Hofmeyer can refer us to that evidence of Ms. Memela, if that is possible.
Okay.
Thank you, Chair.
Chair, I'm just going to have to find it. It's in her affidavit. I didn't take a reference. I didn't
Yes.
actually think it would be contentious, but if you could give me a moment, I'd appreciate
that's
it.
fine. It looks like you don't have any junior helping you today, Ms. Hofmeyer.
No, I do have her helping me, but she's not present in the room. She's
Oh.
available to me on WhatsApp communication, so she can certainly be looking for it too. Chair, my challenge at the moment is we explored it. I'm looking for it in the affidavit. We explored it further in evidence. I do have a reference in on my computer, so if I could come back to it, that would be preferable,
later on,
if I may. I don't want to delay things too
okay.
long in finding it.
Okay.
So I understood you, Ms. Kwinana, to say that it really depends on the circumstances. Is that right? If you happen to encounter somebody out one evening and you don't make the association that they're a bidder and you're a decision maker, then you could communicate. Is that right?
Yes.
But if you knew that you were the decision maker and you knew that they were a tenderer and they knew that they were a tenderer, then you shouldn't have communication, should you?
Still, Chair. That would depend.
You are away from the mic. Your previous answer was yes, is that right? To the question that was asked earlier on.
Can you repeat the question, Ms. Hofmeyer?
Yes, I was saying if everyone knows that you're a decision maker and that they are a tenderer and the tender is still open, you shouldn't be communicating. And I understand you to say, no, you could still communicate. Is that right?
You could still communicate. It would depend what is the role of the person at the time. And that is one. Secondly, you know the issue of conflict of interest. The issue of conflict of interest is a serious challenge in the sense that the procurement process would say you cannot meet with the person or you cannot communicate with the person. what if you are meeting and you are communicating on something else?
Well, if the procurement rule is you can't communicate, it doesn't matter, does it?
So that's why I'm saying it depends on the circumstances.
Yes, so if the procurement rule said you can't communicate, and you were a decision maker and they were a tenderer, and let me add, the person you're dealing with is a director of the company who's tendering, then do you accept it would not be in compliance with procurement rules to communicate with that tenderer?
That would need to be specified, Chair. That would need to be specified because, as I said, if I am not involved in this tender.
No, remember, she's talking, Ms. Hoffman is talking about a person who is a decision maker in the tender. She's not talking about somebody who is not a decision maker. So this whole question about
You
whether
talk
you may
with a
meet,
person who's a decision maker.
hang on. This whole question about whether you may meet or you may not meet somebody whose company has put in a bid and the tender is still open relates to the context of you being a decision maker in that tender, not some secretary or somebody.
A decision maker in this tender, and then the other person is also a bidder, and the person knows
Yes.
that there is a bid.
Yes.
And-
Yes. And he says, both of you
And
know.
there is no room to disclose. Because again, the tender processes allow for a disclosure.
What Ms. Hoffmeyer seeks to test with you is your understanding of what the rules at SAA were in regard to such communication between a decision maker in regard to a certain tender that is still open and somebody who is a bidder in that tender. So you said, as I understood what you're saying, what you said that a communication between the decision maker and that tender and somebody who has tendered or whose company has tendered may be acceptable or permitted in certain circumstances. And she seeks to establish what those circumstances are. And she says, let us say you know that this person is a director of a company that has put in a bid. So you know that this person that you are communicating with is a director in a company that has put in a bid, which you will decide. And she asked the question, are you saying that your understanding was that there would be nothing wrong with communication between a decision maker and such a person while the tender was open at SAA?
It may happen, Chair, that I am a decision maker at this site, and the bidder on that other site is a company. And this person I am talking to does not even know that his company has bidded for this. So that's why I'm saying...
Let us say he knows. Ms. Hoffmeyer said everybody concerned, you know what your role is in the tender, namely decision-making. He knows also, or she knows, that person knows that you are a decision-maker in this tender where his company has put in a bid. You know that he's a director or she's a director of that company. Everybody knows everyone's role.
Chair, it still depends again. It depends on the whole lot of things. That would also include, as I said, the disclosure, because the tender processes, even the government tender processes, I do tenders every day. I went to submit a tender today. It doesn't say if you know a person, you mustn't tender. It says, if you think that your decision will be impaired and you need to disclose that. It doesn't say you mustn't tender. And it doesn't say you mustn't
let's
meet
talk
a
about the
person
decision
because
maker. Let's talk about the decision maker, not the bidder. Can you, on your understanding, if you were a decision maker in a particular tender which has not closed, would you have been permitted to communicate with the director of a company that had put in a bid and you were to make a decision on the bid in terms of procurement rules applicable at SAA?
no,
or in general?
that would not be right, Chair.
That
If
would
I
not be
am a
right.
decision maker this side and the person is a decision maker responsible for this tender, then that would not be right.
Okay, all right.
I did find the reference, Chair, and I've been ably assisted in that. So the first place you find it is in Ms. Mamela's own affidavit. I'm going to read it in, certainly Ms. Mbanjwa can take a look at it if she wants to, but I don't suggest anyone else needs to. It's DD 25A, page 10, paragraph. It's very difficult. Ms. Mamela's paragraphs were not numbered, but it's the third paragraph on page 10. She says there, this is also the time, because she's page 10. She says in the third paragraph there, this is also the time when Air France went and met with the then acting CEO, Mr. Nico Bezuidenhout, and Mr. Barry Parsons, and this is the part that's important, against the rule of the tender that does not allow the bidders to meet with anyone who is a decision maker from the company whilst the tender is still running. So that's the basis for my question.
Yeah.
That's why I put it, it was elaborated on in evidence, but that's sufficient for present purposes.
Yeah.
What position did Ms. Mamela hold at SAAT?
Head of procurement.
So the head of procurement at SAAT actually goes further. I didn't remember this. She goes further. I talked about communication. She says you cannot meet anyone who is a decision maker from the company while the tender is still open. And do I understand your evidence to be you disagree with her?
Yes, Chair.
You can still have those communications.
Yes, Chair.
And even if you're a decision maker and they are a bidder.
As I elaborated, Chair, if I am a decision maker this side and a bidder, assuming that a bidder is a company,
Yes.
and I meet, and the chairperson went further to say, if I am a decision maker here and I'm going to decide on this tender, and the person on the other side is involved in this tender.
Then you accept you can't communicate. Is that right?
Yes, exactly. And we both know that this is the tender. Then that is not right. However, if a person in that company doesn't know about this tender, is not involved in this tender, then what would make that person not to communicate with the person who is a decision maker here? Because that person is not involved, and as I was saying, he may not even know that there is a tender that is going on.
Ms. Kwinana, with fairness, and again, as the chair redirected you previously, you keep answering the question from the standpoint of the tenderer. We're interested in your answer because you're the decision maker. And you've now clarified for us, if you're the decision maker and you're dealing with somebody who is responsible within the company and has put in a bid, you agree you can't communicate, correct?
Yes.
Now you change it and you say, but what if it's somebody else in the company who you're dealing with who doesn't know?
That's why the chairperson was specific to say, this person, this site is a decision maker on this tender. And then the person on the other side is preparing this tender. And therefore, I know that this person I am talking to is preparing this tender. Then that is not right, provided we talk about this tender. Because
No,
I
Ms.
think
Kwinana, I understand. The question is whether you can communicate at all. It's not about what you communicate about. It's can you communicate at all? What is your answer to that?
I don't see anything wrong because we are not talking about this tender.
Well, how could it possibly be fair to the other tenderers that somebody they're competing with has access to a decision maker to communicate with them and they don't? How would that be fair?
What would make them not to be able to communicate with me?
What would make them not be able to communicate with you is that if you ever got approached, you would say, I cannot deal with you because there is an open tender, and it would be in defiance of procurement law that I engage with you now while the tender is open. That is what would stop them.
But still, when you are saying that, you are communicating with that person, you've already breached that rule, if it's anything to go by.
Okay, all right. Hang on a second. Ms. Mbandra?
Please, Chair, I'm not saying Ms. Hofmeyer did not read this line because I was still battling to get this. But from that paragraph that was read in page 10 of Mrs. Memela's affidavit, it is said at the end, but Air France was not disqualified because Mr. Bezuidenhout and Mr. Parsons were not part of the evaluation nor adjudication team. And the reason why I'm reading this penultimate and this very last line is because my understanding of my instructions are Mrs. Kwinana, when she was a director at SAA and the chairperson of SAAT, was never part of the evaluation and adjudication team. That is one. Then the very last one. The second thing, I do not know if it's me who missed it, but if there is a conflict of interest policy at SAAT and SAA, if Mrs. Hofmeyer can kindly refer me to that. Thank you, Chair.
Yeah, no, okay, let's continue. It's matters you can deal with in re-examination.
Indeed,
The
thank
other
you, Chair.
questions, yeah.
Right. I think I have an understanding about where you regard the limits of communications in procurement.
But hang on, before you proceed, Ms. Hofmeyer, I just want to understand what your evidence is, Ms. Kwinana. I think your latest answer seems, as I understand it, to be saying, in the situation that Ms. Hofmeyer is putting to you, where the decision maker from SAA communicates with somebody from a bidding company who is involved in the bid or tender, understood you to be saying now the decision maker can communicate with that person. It depends what they communicate about. Whereas I understood you earlier on to say, no, in that case, it would not be right for the decision maker to communicate with that person. And I thought you said that without any qualification. Did I misunderstand you?
The decision maker, Chair. We talked about the decision maker in this tender, for example. And then the decision maker in the other company who is submitting this
Or somebody
tender.
involved in the tender in the company that is put in
Somebody
a bid.
involved in the tender
Yeah.
in the company. And both of them know that there is this tender. And then they come together and talk about this tender, then that is not allowed.
But now you have said they come together. At that stage, we just talked about communicating, how they communicate. We didn't talk about that. So are you saying what you say would not be right is for them to come together and communicate about the tender? But if they phone each other without coming together, it would be fine? Or
But still, even if they phone each other, Chair, but if they phone each other on this tender, then
So-
that is also not right.
But am I right to say your evidence earlier when you say it would not be right? Your evidence didn't put any qualification. It was simply that it would not be right for the decision maker to communicate with such a person while the tender was open. Am I right that that's what you said?
If that's what I said, Chair, let us take this one that I am saying now.
Yeah.
I am saying, if I am the decision maker, I am going to decide on this tender.
Yeah.
And my decision is going to be impaired on this tender. And the person on the other side, I am communicating with him or her with regards to this tender. And the person was involved in this tender, then that is not right.
Are you saying it is not right if you communicate with that person about the tender, but there's nothing wrong if you communicate with that person about other matters?
Yes, Chair.
Okay, Ms. Hoffman.
I understood you, just to clarify again, to say it matters whether you're going to be influenced by what you're discussing. Is that part of your qualification?
Yes, because now you are talking about this tender, and now your decision by you talking about this tender will be influenced. Also, the influence will play a big role.
Right. So can I say, Ms. Mbanjwa might be interested to hear me say this, but this is a part of Ms. Mamela's evidence that I completely agreed with, and I think we were on common ground. She was quite clear, as we've seen, that it's meeting anyone, right, at the time when the bid is open. I understand you to say, no, it depends on whether what you discuss influences the decision maker, correct?
Yes.
And then I'm wanting to put to you how extraordinarily difficult that would be to be a procurement rule. Let me explain to you why I say that. So imagine now state-owned entities around the country can go out on tender, and the decision makers can communicate with tenderers, some when they want to,
Can go
others
and
when they
sit at
don't.
a restaurant with
Yes,
a tenderer.
indeed. And all of that is fine, just provided in their own minds they're not being influenced. Is that what you say proper procurement is?
So what's your question?
My question is that proper procurement? That it would leave it to the decision or the feeling of the decision maker whether they'd been influenced or not by that communication?
This clause that Ms. Mbanjwa was talking about states exactly what is happening practically. Ms. Mamela was saying people at Air France did communicate with decision makers and they were not disqualified.
Ms. Kwinana, that was not actually my question about Air France. I'm just trying to get a grip on your understanding of procurement. Because as I understand your evidence, you don't agree with Ms. Mamela, who is the head of procurement at SAAT. You are now designing a new rule, a rule not the one that she agrees with, a new rule that says decision makers can communicate with tenderers while the tender is open, provided the decision maker doesn't feel influenced. And I'm putting to you that would be a very risky procurement rule to be in place. Do you accept that?
As Ms. Mbanjwa has pointed out, She made example exactly in respect of what you are saying. The example that
Well,
much as the policy is saying that, what
look
is,
this side, Miss.
much as the policy is saying that, what is happening on the ground?
Leave
is-
out what is happening on the ground. Let's talk about the rule or your understanding of what the rule was.
My understanding of the policy, of the
Or
procurement
the
policy,
yeah.
my understanding of the procurement policy in a nutshell is that you cannot communicate. When you say you cannot communicate with the bidder, if you look at big companies, take maybe Steinhoff, if it's the good example anyway. If you look at big companies like Steinhoff, there would be a person who is doing the tender. And there will be the person who is putting together everything up to the submission. Now, there is another person on the other side, let's say SAA. Maybe SAA is small compared to Steinhoff, but let's talk about, if we say SAA, if the person at Steinhoff has been doing the tender, and then that person meets with a person at SAA who is not involved in any way.
No, we said decision maker, Ms. Kwinana. We're not talking about somebody, we're not talking about a secretary. We're talking about a decision maker at SAA and
In the
somebody
tender.
in the other company, call it Steinhoff or whatever, who is involved in the tender. Those are the people we are talking about.
But Chair, what would, of course, I know I'm not supposed to ask questions, but maybe that is a rhetorical question.
Well, the question is, we want your understanding of what the rule was at SAA or what the rule is. But we're talking about that particular time when you were a board member. We are saying, if you were a decision maker at SAA in regard to a certain tender that has not closed, were you permitted to communicate with somebody who comes from a company that has put in a bid in regard to that tender, and that somebody is somebody who has been involved in that tender on the side of that company?
And then I went further to say, if they meet, what are they talking about? If they are not talking about
So
this tender,
are you reaffirming that your answer is they were permitted, they would have been permitted to communicate? The decision maker would have been permitted, entitled to communicate with that person as long as they did not talk about the tender.
Yes, Chair.
Okay, so if some executive from SAA, while you were chairperson of the Audit and Risk Committee, approached you and said, you know, the managing director of this company that has put in a bid here has asked me if we can go and have lunch or dinner while the tender was open, your answer would be, yes, you can go as long as you don't talk about the tender.
Yes, Chair.
And if another bidder saw them sitting at a restaurant and then complained and said, you know, the MD of that company which is bidding here, I saw him or her sitting with the decision maker at a restaurant, you would say, what were they talking about? Is that what you would say?
Chair, the bidders complain all the time. Even the people who have not bidded, like Ms. Sambo, do complain.
Yes, but what I'm asking is whether your concern would be whether that person has got proof that they were talking about the bid, the tender.
Yes, Chair.
And how would he know?
How would he know, Chair, if we are not talking about
If he was
the
not with them, he just saw them.
Yes, Chair.
Obviously, if he joined them, they would not talk about it.
No, but Chair, whether they were talking about it or they are not talking about it, the other person would not know.
Yes, which is why the rule may well be, I haven't looked at the rule, but I would understand if the rule prohibits communication absolutely, because those who drafted the rule would have known how difficult it would be for somebody else to prove that they were talking about the tender. And so the best way, if you want to ensure that there are no complaints, you say no communication until after a certain period. Because if you say there can be communication, but not on the tender, it's going to be difficult to prove that. And then in terms of transparency, in terms of fairness, there are going to be a lot of complaints.
As I said, Chair, in theory, that's how it is supposed to be. The people that I was going to mention here this morning, that you said they need Rule 3.2, is still at SAA, and he has been communicating with the suppliers, and he has been communicating with the tenderers. So basically, much as that is said in the procurement policy, but it's difficult. One of the reasons why it is difficult, and in fact almost impracticable to apply it, is because some of the bidders may be doing work with the company at the time, and therefore they may be coming in and going out of the office because they are doing work whilst there is also another bid that is going on.
But you understand what I was putting to you, how difficult it would be.
It would be difficult.
Yes. Ms. Hofmeyer.
Thank you. And then just to close it off, so if one of the bidders wined and dined decision makers and took them on planes and drove them around in limousines while a tender was open, that would all be okay provided they never spoke about the tender. Is that right?
Chair, if you are talking about AAR, there was no tender when we went to Chicago.
I'm talking now about the
She's
rule.
putting a certain question to you in general in order to confirm her understanding of what you say in terms of your understanding of the rule. So just answer that. If and when she wants to talk about whatever you have in mind, you will deal with it at that time. But she's just talking in general.
As I said, Chair, in terms of the practicality of it, if, for instance, we assume that we were taken to Air France, and Air France was doing the work there, and Air France was doing the tender, and Air France is not taking us because of this tender, but is taking us because we are the current clients. That's why I'm saying it's difficult to deal with the procurement policy as it is.
So you cannot apply the procurement policy when it's difficult to do so. Is that
Yes.
your evidence?
Not when it is difficult, when it is impracticable to do it.
So you, as a member of the board of SAA Technical, may not apply the procurement policy of SAA Technical when it's impractical to do so.
Of course, if it is impractical, how are you going to apply it? You can't apply it if it is impractical.
I'd like to move on, Chair, if we
Yes,
may.
yes.
And I'd like to now focus, Ms. Kwinana, on what I'm going to call quite a fateful week in the life of SAA. And it's the week that started on Monday, the 28th of September, 2015, and ended on Friday, the 2nd of October, 2015. Okay, let's start at the beginning of that week. At the beginning of that week, Monday, the 28th of September, 2015, the board of South African Airways, including you, decided to cancel a tender that had already been awarded to LSG Sky Chefs and instead to award it to Air Chefs. Do you remember that?
Oh, Chair, I like that one. And in fact, even before you go further, that is the decision the cancellation of that tender.
Hang on,
Oh,
Ms.
sorry.
Kwinana.
Sorry.
She has only asked you whether you remember that.
No, I'm saying, Chair,
So at this
that
stage,
decision, I'm saying, Chair, that decision of us.
no,
as
she
the
will
board
get,
of
she will ask you
SAA.
about the decision.
No, that's, Chair, maybe let me first.
No. We are going to waste time if you
No,
answer
Chair.
questions she has not asked.
I want to say this. I
No,
want
no,
to
you
say
will
this.
get a chance to say
No, but
it.
Chair, let me say it now before we go any
Ms.
further.
Ms. Kwinana, I control what happens here.
Okay.
I'm saying you are not going to answer that now. You may answer it when she asks you about it. Okay. Do you remember or do you not remember that?
There is no way that I would not remember. That was one of the best decisions
Yes,
that I made
okay.
at SAA.
Ms. Hofmeyer?
One of the best decisions you
Of
made,
course,
is that correct?
yes, yes.
And you did address this in your affidavit in response to the chair's questions. Do you recall that?
Sorry?
You addressed this issue
Yes.
in your affidavit. I'd
Yes.
like to take you there because it seems to be a decision that you are
Very
resolute
proud of.
in being proud of.
Yes.
Excellent. So let's go to it. Pick it up at page 4 in your affidavit. Chair, that's Exhibit DD 33. At page
Yes,
4.
thank you.
And again, your affidavit is also differently numbered. You have to go to the bottom. It's add C, because you're responding to paragraph C of the 10.6 directive, and the heading is SAA Board's decision on 28 September 2015 to cancel the tender awarded to LSG Sky Chefs. And then what I understand follows is, well, first of all, you say, you point out that you are, quote, flabbergasted
Yes,
by the
I
question
am.
from
I am
the
very
Commission.
flabbergasted. Yes, Chair.
And maybe explain to us, why are you flabbergasted by the question?
I am flabbergasted by this question. The reason being that
I'm sorry, Ms. Hofmeyer. Just so that the public who are listening can follow.
Yes.
Start with what the question is,
Certainly.
and then we can hear why she's flabbergasted.
Indeed. What the directive required is that Ms. Kwinana would tell us everything she knew about a series and her involvement in a series of topics, right?
Yes.
And so C actually records the topic. The topic is the SAA Board's decision on 28 September 2015 to cancel the tender awarded to LSG Sky Chefs. And
So C
yes,
was
is a replica.
Was a question requiring her to share with the Commission
Yes.
whatever she knows about the board's decision of 28 September 2015 to cancel the tender award to LSG Sky Chefs.
Exactly.
That's the question.
Yes.
Okay, now when you say you are flabbergasted, then the public
Yes.
can understand what question flabbergasted you.
Chair, when Mr. Mutibe was asked about
I'm sorry, I think Ms. Hofmeyer's question was, why were you flabbergasted by this question?
that's what
from
I'm
the Commission?
explaining, Chair. That's why I'm.
That's why where you are going, okay.
Yes. I'm saying, Chair, the reason why I am flabbergasted by this question is that I really would not even think that it would be part of the inquiry here in view of the fact that Air Chefs was going to retrench people, and Air Chefs is 100% subsidiary of SAA, and therefore it is a government entity. And the reason why Air Chefs was formed is mainly to service SAA. So which means therefore that if they were no longer going to service SAA, there would be job losses. That's why I even said whoever made this decision is causing a sabotage. That's why I said that is how strongly I feel, and that is how strongly I still feel about it as I am sitting here. Our decision as the board to cancel that award against Sky Chefs and take it back to Air Chefs Air Chefs employs or employed 1,500 people at the time. And those 1,500 people would lose their jobs. And then now look at the other suppliers of Air Chefs. Some of the smaller suppliers of Air Chefs would lose the jobs. For a Lufthansa company, oh really, Chairperson, no. That's why I am saying I am flabbergasted.
Well-
And in fact, the evidence leader even forced Mr. Pule Mutibe to say this cancellation should have been reported to IRBA as a reportable irregularity because we cancelled this tender irregularly. And my understanding of the reportable irregularity is that an act must be done at management and it must cause financial loss. Now, what does advocate say about the financial loss that would be incurred by Air Chefs? So that's why I am saying...
But are you saying it was not going to be a reportable irregularity?
No, Chair, I don't see any reportable. In fact, it would be a reportable irregularity if this tender had continued to be given to the Sky Chefs. The reason being that there would be job losses. And in fact, this was supposed to go to tender and this was supposed to go to the shareholder in terms of Section 54 of the PFM Act. The reason being that this would be the discontinuation of the bigger portion of SAA Group. And therefore, that would be the reportable irregularity.
Maybe I will understand the flabbergasted part later, but I think you must continue, Ms.
Indeed.
Hofmeyer.
Thank you, Chair. So, Ms. Kwinana, I understand you to say your main concern were the job losses that were going to result at Air Chefs if you retain the award with LSG Sky Chefs. Is that right?
Not to retain because that tender, or let me not say that tender, SAA was being supplied by Air Chefs, which is a 100% owned subsidiary. And in fact, I had Ms. Mche suppressing the fact that Air Chefs was a 100% owned subsidiary of SAA. And thanks to the judge, because to the deputy chief, with the chairperson, because you asked a question whether Air Chefs was not a 100% subsidiary of SAA, because she was suppressing it.
You think Ms. Mshe suppressed evidence before this commission?
That's what she did.
Is that your evidence?
Yes, that's what she did. Yes.
She suppressed it?
Yes, she did.
Did she suppress it to you at the time when she was advising you on this award?
You know, if I can talk about Ms. Mshe and her disregard of the board decisions, this one was one of them.
Ms. Kwinana,
Chair.
please, it's in your interests and it's in the interest of all of us that as the evidence leader asks questions, you listen carefully to what the question is and answer that question, because in that way we'll make progress much more easier. I think your last answer didn't answer her question. It dealt with something else. I'm going to ask her to repeat her question, listen carefully, and answer that question.
Your testimony today is that Ms. Mshe suppressed evidence before this commission. Is that correct?
Yes, Chair.
And I asked you, do you regard her as having suppressed evidence when she was engaging you about this award at the time that it was made?
Yes, Chair, she did. She did suppress it because, as I said, although the amount itself did not require the board decision, but the nature of the transaction required that it needed to go to the board because Air Chefs was going to close down. And in fact, it did not even need to go to the board. It needed to go to the shareholder in terms of Section 54. And he suppressed all of that.
Did you read any of the emails that Ms. Mshe was circulating to the board after that fateful day in Parliament where Ms. Mieni was criticised for this award?
Ms. Myeni was criticized of this award. Who criticized her?
Members, when she addressed the Portfolio Committee, I think it was on the 1st of September, I always get wrong on this, the 2nd of September, she was asked a quite inflammatory question about the award of this tender to LSG Sky Chefs, and she was asked whether that was done because she took it that, quote, black people can't cook. Do you remember being aware of that at the time?
Yes, I'm aware of that.
You're aware of that. So that happened on the 1st of September. And then in Ms. Mshe's evidence, she explained in graphic detail how distressed Ms. Mieni was by that encounter, how she berated Ms. Mshe outside the meeting room in front of Ms. Mshe's other colleagues. And subsequent to that, Ms. Mshe was called to account for what had happened. In that process, she sent numerous emails to all the board members. And I'm trying to establish now whether you read any of those emails of Ms. Mshe at the time.
I may have read them, Chair, but regardless of what those emails were saying, they would not change how I felt at that time, and they would not change how I am feeling at this time.
Yes, Ms. Kwinana, the answer was whether you read any of those emails. I think your answer should be you may have read them, you may not have read them, you can't remember. I think that's what you're saying.
I may have read them.
Yes.
Most
When you are
probably.
referred to a particular email, you might see when you look at it whether
Yes,
you
yes,
remember reading it or not.
Yes, Chair.
Okay.
And I think I understand you to say whatever Ms. Mshe was saying, you took the view that it would cause job losses
Yes.
if it remained with LSG Sky Chefs, correct?
Yes.
And that Air Chefs would close down its business.
Yes.
Is that correct?
Correct.
Right. And then you hesitated when I said to cancel the award to LSG Sky Chefs, because an entire tender process had been run prior to this. Were you aware of that?
Irregularly so.
Why was
because
it irregular?
This tender was irregular for the reason that I am saying. Why would, in fact, when I make this example of this LSG Sky Chefs, is if my daughter is selling fat cakes here at home, why would I go and buy fat cakes next door? And then if I decide to go and buy fat cakes next door as a parent, am I not supposed to tell the child that I don't like your fat cakes? This is how you should do the fat cakes. Then please correct here and there and so on. So the reason why I'm saying it was irregular is because that tender should not even have happened. Why would, in fact, had that tender went on, also that would be the same with SAA Technical. We would see some aeroplanes being repaired elsewhere because we would have created a precedence for that. That's why I'm saying that that's one of the best decisions that we made.
So when you say it was irregular,
It was
it's not-
irregular,
Hang
Chair.
on, Ms. Kwinana. Everybody allows you to speak. So
Sorry, Chair.
when you say it was irregular, you don't mean there was a process that was supposed to be followed but was not followed. You only mean that substantively you disagreed with the decision to award it to this company. That's what you mean.
Plus the process, Chair, because
What was wrong with the process?
Because the process, the discontinuance of the major component of the business requires a board decision, and it also requires a Section 54 application.
Yes, okay. Ms. Hofmeyer.
You were told by Ms. Mshe why the decision had been taken to go out on tender, and that had to do with the fact that Air Chefs had previously been providing the service and was doing so to great customer dissatisfaction. Were you aware of that?
That's why, Chair, I was saying I was aware of that. That's why I was saying the responsibility of the parent is to guide the child, to say, you're not doing right here. Then do like this and this and this. Not to do what Ms. Mshe was doing.
Because prior to Ms. Mieni appearing in Parliament and being questioned about this, there was a detailed memorandum sent to the SAA Board of Directors explaining the whole process, explaining why the decision had been to go out on tender. I'd like to take you to it if I may. You'll find it in Mr. Motibe's bundle. Chair, that will be DD19A, and you'll pick it up at page 132.3.1. You'll be assisted now, Ms. Kwinana.
Okay, let's go to the page first.
So it's Exhibit DD1919A. And when we're looking for the page, we'll be looking for page 132.3.1.
Which one is it this one?
Don't think. So we're going to have to find 132.3.2 in that, please. Point 3.2. Oh, sorry, it starts at point 3.1. Apologies. If you bring it to me, I can possibly assist. I've lived these files for longer than anyone. So this is a memorandum that Ms. Mshe, as the Acting Chief Executive Officer, prepared for the SAA Board of Directors, dated the 20th of August 2015. And you'll recall that precedes the meeting at the Portfolio Committee. And what she says in the background section, that's midway down the page, Ms. Kwinana, is she says there, SAA's lounge customer value proposition, product and service, has to date been provided by SAA's subsidiary, Air Chefs. The food and beverages on offer are specified in line with customer needs, preferences, and expectations. Over time, SAA has experienced a severe deterioration in the quality and standard of product and service delivery offered by Air Chefs, based on premium customer complaints in respect of the customer value proposition at ORTIA's lounges, which are ranked as high-value customer touchpoints. The negative customer experience has not only detrimentally affected SAA from a reputational and commercial perspective, but has also resulted in SAA's premium customers beginning to use the slow lounge, British Airways customer value proposition, which is SAA's competitor. And then she goes on and she explains, because of that challenge with the service delivery, the impact it was having on SAA both reputationally and commercially, there was then this decision to go out on tender. Were you aware of that at the time, Ms. Kwinana?
Chair, I was not aware about the decision to go out to tender. We became aware of this when we were asked in Parliament.
So why did you not become aware of it a week or so earlier when the memo was prepared?
I'm not sure if this memo was prepared before they went out to tender, or it was prepared for the Zondo Commission.
No. It's a historical document. It's a document dated the 20th of August. So they've gone out on tender.
Definitely.
They've run the whole process, and now she's alerting the board
I see.
about the process before you went to Parliament.
Or they've gone out to tender. That's the
Yes.
problem. That's the problem, Chair. They were not supposed to have gone out to tender.
Yeah, but she's not asking you about that. She is saying this memo from Ms. Mshe is dated 20 August 2015.
Yes.
The meeting at Parliament appears to have been on the 1st of September 2015. She's asking why you would not have been aware about a week or 10 days before the meeting in Parliament, since this memo from Ms. Mshe was addressed to board members.
It would be good if other board members would confirm this memo, because I really do not trust it.
You really don't?
I don't trust it, Chair.
You don't trust?
Yes.
Trust?
Yes, I don't trust this memo, Chair.
You don't trust that
yes,
it is
because-
authentic?
Yes. The reason why I do not trust it, Chair, is because we were all surprised by this revelation in Parliament. So it may happen that she may have prepared it and did not send it to the board.
Okay.
Could it also have been like in the case of the Swissport ground handling contract, that you got it and you just didn't read it?
The contract, no, Chair, I did not get the contract. We do not get the contract in the meeting. We get the submission, and then if there is an agreement, then management goes back to write the contract. So in the meeting, we do get the submission, not the contract.
No, but
that's
that
why,
could not...
that's why I was saying I do not want to read that contract because I am not party to it. The only thing that I would do is to, if it is available, is to read the board resolution and see if it has been translated correctly in the contract. But remember that the contract is the management document. It's not my document.
But Ms. Kwinana, it's a pity you are taking us back to this thing. As a board member, if a certain contract required board approval, you would want to see the contract before you approve it, because why would you agree to approve a contract you have not seen?
No, Chair. This is how the process, the approval process happens. You come to the meeting with a proposal, and then now there is an agreement to say now you can go and enter into a contract, and then management goes back and enter into a contract, and they file it. They don't bring it back unless there is something that requires that in the next board meeting, the contract is brought back.
But if the requirement is that you must approve the contract, you have to see the contract. You can't approve it until it exists. And
No,
you can't
Chair.
approve it unless you see it, because otherwise you are going to approve a contract whose terms you don't know.
Chair, that is the misunderstanding that we had before lunch. That is the misunderstanding that we had before lunch. What comes to the board is a submission with the terms and conditions to be approved. And then when those terms and conditions are approved, then that's when management goes back and put it in a contract.
You never, as a board, want to see the actual contract to see whether the terms that found their way into the contract are the terms that you approved.
Chair, there are so many assurance bodies in an organization. There is internal audit, there is external audit, there is risk management.
No, but I'm talking about, Ms. Kwinana,
contract people.
if the policy or the regulations or the law says this type of contract must be approved by the board. I'm saying, how could you approve a proposal and end there? A proposal to enter into a contract on the following terms and never say, we want to see the actual contract that you entered into when you say to management. We want to see the actual contract so that we can see whether you actually carried out what we approved. We want to see whether the actual terms in which you entered are the terms that we approved or you did your own thing.
Chair, the contract document does not come to the board. What comes to the board is the submission.
Okay,
Which-
Ms. Mbandwa. Ms. Mbandwa, Ms. Kwinana. Please carry on.
Thank you, Chair. We were dealing with the memorandum that I understand Ms. Kwinana's evidence to be she doesn't trust.
I'm sorry, Ms. Hofmeyer, just the last thing, and I'm just want to raise this because this kind of horrifies me. So does this mean that during your time when you were a board member at SAA, there may have been a lot of contracts where the board approved that the management must negotiate and enter into without the board ever seeing, once the contracts had been signed, whether the management did its own thing or whether the management entered into contracts on the terms approved by the board.
Not the actual contract, Chair, but the terms and
Yes,
conditions.
no, but I'm saying, does it mean that there would have been many
Oh, yes, Chair.
contracts where
Yes.
you never saw the ultimate contract, whether it was in accordance with the board's terms and conditions? You just said, go and enter into a contract along the following terms and conditions, and you left it at that.
Yes, Chair. And in fact, that is also part of
Yeah.
our trust in the caliber of management.
Well, you
Yeah,
didn't
well-
have any trust in the caliber of management, did you, in August of 2015?
Ms. Mshe?
Just Ms.
Yes,
Mshe. You didn't have any trust in her caliber.
Not in everything, but in the decision of LSG. In the decision of LSG, then no.
So we were just establishing whether you knew before you attended Parliament that there'd been consideration given to why they wanted to go out to tender. And we saw here what that motivation was. That because of the substandard performance of Air Chefs, it was having a reputational and commercially negative impact on SAA. Were you aware of that before you attended Parliament?
As I said, Chair, I made an example, a very easy example of the fat cakes. I wouldn't go next door and buy fat cakes and leave my child's fat cakes here.
Ms. Kwinana?
Even if I had a challenge with them, if I have a challenge with them, I would say, reduce the baking powder, add this and this and this, so that it can be to the customer satisfaction.
Ms. Kwinana, what was my question?
Forgotten about it.
It's because you repeatedly, with respect, Ms. Kwinana, do not answer the question. It was simply a question about what you knew. Did you know, when you attended Parliament, that the reason why SAA's management had decided to go out on tender was because Air
Ms.
Chefs
Kwinana.
I
was
said
sub...
advocate.
Ms. Kwinana, Ms.
I
Kwinana,
only knew about
Ms.
the
Kwinana.
award. I only
Ms.
knew about...
Kwinana, when I call you, please keep quiet.
Sorry, Chair.
Ms. Hofmeyer has not even finished asking you the question. And yet the
Apology,
previous question, you admitted you could not remember what the question was. The reason why she has to repeat the question now is because you did not listen to the question and answer the question. And now when she's repeating the question for your benefit, because you didn't listen before, you start talking before she can finish. We are going to waste time if we do it like that. I've said to you before, please It is in your interest and in the interest of everybody that when she asks you questions, you keep quiet and listen carefully and then answer that question. I'm going to ask Ms. Hofmeyer to repeat the question. This time, just listen carefully.
Were you aware when you attended Parliament on the 2nd of September that the reason why SAA's management had decided to go out on tender for these lounge catering services was because Air Chefs, the prior provider, was providing substandard performance which was having a reputational and commercially negative impact on SAA? Were you aware of that?
No.
Okay. Did you become aware of it after attending Parliament?
Yes, Chair.
Yes. And I take you to disagree with that. Is that correct?
That's fine.
Now, your reasons for disagreeing, sorry,
We are
Chair.
at 4. We have agreed we will all go beyond 4 o'clock, but maybe we should take a break.
Certainly.
But if you have a question that you
No,
want to ask.
we can take the break now.
Okay.
I'm very comfortable
Let's
with
take
that.
a break and resume at 4:15. We adjourn.
Usitshayisa ngabani ixesha? Ngo-6? 6 o'clock? It depends on.
let's continue.
Thank you, Chair. We were dealing with the memorandum that Ms. Kwinana does not trust, dated the 20th of August 2015. And Ms. Kwinana, I referenced 2 paragraphs where the background to why the decision had been taken to go out on tender was recorded. But what is noteworthy, I want to suggest to you about what else Ms. Mshe says in this memorandum, is that she actually takes up your very point. The point about shouldn't the parent be assisting the child? Are you aware that she addressed that very issue?
No, Chair.
And as you sit here today, you don't have a recollection of ever reading this memorandum, is that right?
No, Chair.
Well, what she did say, addressing the board, is that, and I'm now, Chair, just for the record, DD 19A at page 132.3.1, the same page we were on previously. But I'm now going to read from the last paragraph, sort of half of the way down, because what she records there is she says, several interactions were held between SAA and Air Chefs to find means to improve the level of service delivery achieved. However, and notwithstanding these efforts, no improved results were recorded. SAA was accordingly faced with no option but to take a decision to go out on a confined tender to achieve the desired commercial value proposition expected for this premium customer segment. So you weren't aware that there actually had been efforts between SAA and Air Chefs to do the very thing that I think your Vet Cook example is supposed to convey, correct?
I was not aware, Chair.
Now you are, so are you satisfied that they did take steps to do the very thing you were concerned about?
I'm not satisfied, Chair, because as I said, I don't believe this memo.
But if it is true that they did take those measures to try and get HFs to improve its level of service delivery, but those efforts did not succeed, would you accept that in that case then, if that is true, then it would be understandable and justifiable for them to look elsewhere for service of the right quality at the right level?
No, Chair, I wouldn't understand it.
Sorry?
Chair, I wouldn't understand it. Of course, if your child doesn't listen to what you are saying, let's say your child doesn't want to go to school, he bunks school, you handhold that child and take him to school. So basically, I just wouldn't understand. I still don't understand, Chair.
Are you saying that there could never be a point where they say, look, we have tried everything with HFs to get them to improve their service, and they have failed? Are you saying that such a point could not be reached?
They would not have tried enough, Chair.
Are you saying, therefore, that they should just go on and on and on, even if they could see that their efforts were not bearing fruit?
No, not going on and on and on, Chair.
Yes.
But I'm saying you handhold your child. You don't throw your child in the dustbin.
Well, leave out the child example now. Leave out the child example. Let's talk about this. This is a business now.
Yes.
It's not at home. This is a business. SAA must be run like a business.
Yes.
Now they are saying, Ms. Mshe is saying this memo, telling the board, over the years or over whatever period when HFs was providing the service, there had been complaints about the quality of the service. They, as management, had made a number of efforts to try and get HFs to improve the quality of their service. And these efforts had not borne any fruit. It was only after that that they decided, look, we must go to open tender. So are you saying that no matter how unsuccessful their efforts were, they should have gone on and on trying to get air chefs to improve their service, even if they realized that it simply was not working?
Chair, I'm saying if they tried, they didn't try hard enough.
Yeah, but they say they've tried hard enough.
Of course, it's their word against mine.
Yes,
I'm
but
saying they did not try hard
yeah,
enough.
but you don't know whether they say to you, we have tried hard enough. Is there a point which you accept
I'm saying,
at which
Chair,
they could say, we have tried enough?
I'm saying, Chair, I was a board member of SAA, and I did not feel their efforts. So that's why I'm saying, if
How
they
could
tried,
you feel their efforts? They were not talking to you, they were talking to HFs.
Chair, the HFs is the subsidiary of SAA. They could not close HFs without informing SAA, without informing the shareholder. They could have even gone up to the shareholder to say, we have given up on HFs. We have done A, B, C, D, and E. So that's why I'm saying they did not try hard enough.
Ms. Kwinana, I want to try and get some common ground because you've said repeatedly you don't trust that memo. So I want to actually go to an email that Ms. Mshe sent directly to you, amongst other people, because maybe we can work with the content of what she said there. So let's go to her actual email to you. You'll find that a few pages on in the bundle you're busy with, DD19A, and it's at page 132.11.
I'm sorry, what's the page number?
132.11.
Okay.
Now, Ms. Kwinana, you'll see that starts with an email from Ms. Mshe, copied to Ms. Mieni, yourself, Mr. Dixon, and Dr. Tambi. CC to many people, and it says in quite big blue lettering there, "Dear board members and colleagues, please note the trailing emails in respect of the lounge discussion today. Please familiarize yourself with the contents thereof, in particular the legal implication and risks associated with the decision." So now we've jumped, well, that is an email dated the 28th of September, but the trailing email that I want to focus on is the one just below it, midway down the page, which is an email that Ms. Mshe sends to, amongst others, you. It's dated the 8th of September 2015. Do you recall receiving that at the time?
Yes, Chair.
You do. And did you read it?
Yes, Chair.
Right. And did you read the trail of emails? You can go through to page 15, because that's the end of this trail. You copied on all of the relevant emails, as I can see it.
Yes, Chair.
Right. So you read it at the time, and I understand one thing you were really concerned about is that this decision would close down Air Chefs, correct?
Yes, Chair.
Now, Ms. Mshe told you that it wouldn't. You remember that?
How would it not close down HFs?
Well, because... No? Well, why don't you tell me how it would?
SAA.
Closer to the mic.
HFs was mainly formed to service SAA, and therefore SAA is a bigger customer, is the major customer of HFs. And therefore, in any business, if you take out the major client, that business is bound to close down.
Yes,
And again, let me finish, Chair.
Apologies.
And again, if, for instance, SAA, the shareholder, the 100% shareholder of Air Chefs, has lost confidence in Air Chefs, what about the other airlines and other customers that were even serviced by Air Chefs? So she was also not telling the truth to say Air Chefs was not going to close. In fact, if you could interview the employees of Air Chefs, they were being retrenched already.
You were worried about that, weren't you?
Yeah.
She also told you they weren't going to be retrenched. Do you remember that?
Where would they work? No, man. Chair.
Do you know where they were going to work? They were going to work for LSG Sky Chefs. It was a requirement that they be taken over, Ms. Kwinana. Were you aware of that?
You know, Chair, we've heard that before. We've heard that before. Air Chefs was going through the retrenchment process.
No, the tender itself and the contract that was going to be concluded required the employees of Air Chefs to be taken over by LSG Sky Chefs. There was not going to be a single retrenchment. That is what Ms. Mshe told you on the 8th of September 2015. Do you not remember that?
I told you, Chair, that Ms. Mshe is suppressing evidence.
Hang on,
that is
hang on,
another
Ms. Kwinana.
evidence that she is
Ms.
suppressing
Kwinana.
because Air Chefs was going through
Ms. Kwinana.
retrenchments. Chair.
Please listen to me. You are not answering her question. You are responding to a question she did not ask. Please stick to answering her questions. Ms. Hofmeyer, do you want to repeat your question?
Well,
Each time a question has to be repeated, we are wasting time.
Sorry, Chair.
Okay.
I asked you whether you were aware that Ms. Mshe told you in her email of the 8th of September that there would be no retrenchments because it was a condition of the tender and the to-be-concluded contract that the Air Chefs employees would be taken over by LSG Sky Chefs. What is your
Chair,
answer to
she
that?
was not telling the truth.
So if I can show you
Well,
the contract.
okay. Yes, Ms. Hofmeyer is saying to you, Ms. Kwinana, the contract that was going to be signed by Sky Chefs was going to include a clause, or did include a clause, to say they must take over the employees of Air Chefs. Now I can tell you this, and Ms. Hofmeyer knows it as well. Maybe Ms. Mbanjwa knows it as well. When this type of thing happens, Section 197 of the Labor Relations Act obliges the new company to take over the employees of the company which has lost the tender, which is no longer going to do the job. So, to the extent that the contract to which Ms. Hofmeyer is referring you may have had a clause to that effect, that would have been in line with the law. But even if that clause was not there, the law, the Labor Relations Act, would have obliged the new company to take them over. You understand that?
Chair.
I know you are not a lawyer, but I'm now telling you what at
Chair,
least a statute says.
Chair, I'm not a lawyer, but what I know is that Air Chefs was going through the retrenchment processes.
Okay, all right. I'm sorry. Ms. Mbanjwa, you wanted to say something at some stage, or has it fallen away?
No, Chair, what I thought Ms. Hofmeyer would refer us to is the tender document that had these conditions that oblige.
Oh, I think in due course she will. Okay, all right.
I'd like to take you to the contract itself.
Yes.
Let's find that. That's in your bundle, Ms. Kwinana, at DD, so that's Exhibit DD 33. Chair, it's under tab 15, and so that starts at page 154.
Yeah.
You'll see that that was the contract that was to be entered into. Is this a contract you saw at the time, Ms. Kwinana?
Are we still on Air Chefs, Chair?
Yes.
DD 33.
DD
sorry, I can't
33,
hear you.
page 154. Under tab 15. Do you have that, Ms. Kwinana?
Yes, Chair.
So that's the contract that SAA was going to enter into with LSG Sky Chefs. Did you see that at the time?
No, Chair, as I said, the board was not responsible to see the contract.
Oh, yes.
So I did not see the contract.
I remember that. But what Ms. Mshe said to you in that email of the 8th of September is exactly what the chair has highlighted. And then I'll take you to the contract and where it references section 197. Let me just tell you what she said in that email of the 8th of September. Ms. Kwinana, you can go there if you want to, but otherwise I'll just read it into the record. It's where we were back in DD 19A at 132.12. She says, there are no job losses emanating...
That's paragraph 7, eh?
Paragraph 7, thank you, Chair.
At page 132.12.
Exactly. There are no job losses emanating from the award of services to LSG Sky Chefs, as any impacted Air Chefs employees will be transferred to the successful bidder as per the conditions set out in the tender document, in accordance with section 197 of the Labour Relations Act 1995. And then just for good measure, so that we could see it in the anticipated contract, I wanted to take you to the contract, which I've done at DD 33, page 154. If you go right to the end of that contract at page 179, you'll see detailed clause 25 imposes this contractual obligation over and above the legal obligation under section 197. So, Ms. Kwinana, is it still your evidence before this commission that Ms. Mshe was, quote, lying to the Board of Directors of SAA when she said in her email to you on the 8th of September 2016, 15, what year are we in, 15, that there were going to be no job losses?
Chair, what I am saying is there were, the Air Chefs was going through retrenchment process.
But not related, Ms. Kwinana, to this contract. This was lounge catering services. Every employee of Air Chefs who was ever involved in lounge catering services was going to move over to the new supplier. How could that possibly then be a reason for you to reject management's decision?
Chair, I am saying Air Chefs was going through retrenchments.
Please raise
Air
your
Chefs-
voice, Ms. Kwinana.
Chair, I'm saying Air Chefs was going through retrenchments. And in fact, this contract...
But Ms. Hofmeyer is saying to you, whatever retrenchments HS may have been going through, if there was any, could not have arisen out of this because there was proper provision for the employees under this contract to be taken over by the new contractor. So if there were some retrenchments or letters of retrenchment that may have been given to employees, they probably did not relate to this. That's what she is saying. Now, do you know whether, to the extent that HFs may have been in the process of retrenching some employees, do you know whether it was connected with this or it could have been connected with something else?
It was connected with this, Chair, because when we subsequently reversed this award, of course the contract was not yet signed, but when we eventually reversed this award, the retrenchments did stop. So which means therefore that the retrenchments were as a result of this award.
So that was your inference from what happened.
Yes, Chair.
But nobody ever said to you that those retrenchments were connected or to this award.
It was a known fact, Chair, because Air Chefs was closing down, and therefore the retrenchments were related to Air Chefs
No,
being
it doesn't,
closing down.
it doesn't follow. You may have thought at that time it followed because you might not have known what Section 197 of the Labor Relations Act says. You might have thought so at that time. You see, the Section 197 doesn't allow that to happen. Even if an employer doesn't include it in the contract, in the agreement, employees are supposed to be taken over by the new contractor. That's part of what the Labor Relations Act has put in place in order to protect jobs for workers. To say when there is a new company coming to do a job that your employer has been doing or you have been doing for your employer, the workers must not suffer. That's the protection that is there. Ms. Mbanjwa, you wanted to say, ask something?
Yes, Chair, I'm not arguing the issue of Section 197. I'm not a labor expert. I will freely admit that, and I know you are from that as. But what I just want to point out is that if one reads in page D33, page 179, in paragraph 25.1, the way that paragraph is couched is not in the terms that have been read here. I will read it for the record. It says.
No, don't read it.
Okay.
We can see it.
Okay, thank you. So
It says the
basically-
agreement is subject to the provisions of Section 197.
Yes. And it does not say, and this is very important for a board member, it did not say that it is a condition of the award of this tender that all employees of Sky Chefs will be taken over.
Okay.
If I may be allowed to finish, Chair. And the second most important thing here, it
Sorry,
is drafted to create...
sorry, Ms. Mbanjwa. That's something you can raise in re-examination or argument. It says subject to Section 197. If you go and read Section 197, you will know that it will cover all employees who were doing the job that will now be taken over by a new company. Ms.
I just
Hofmeyer.
wanted to point out the indemnification, that if it was so tight, then there would be no need to put in an indemnification.
Let's continue, Ms. Hofmeyer, please continue.
Thank you, Chair. I just want to deal with the last point. You said you were concerned about the entrenchments and you were concerned about the fact that Air Chefs was going to close down if this business went to LSG Sky Chefs. Is that correct?
Yes, Chair.
Well, Ms. Mshe told you that it wasn't going to close down, and I think I raised it with you earlier, and you said, how could it not? Because SAA is its main customer. Did I have your evidence correctly?
Yes, Chair.
But you see, what Ms. Mshe went into some detail to tell you in those emails we were looking at previously is how small a percentage of Air Chefs' revenue this lounge services contract actually took up. Do you remember what that percentage was?
No.
You see, at page 132.14, which is in the email trail that we were looking at DD19, she makes it clear, and I'm reading under point 1 on that page, on the email on which you were copied, on the 3rd of September 2015 now. She says the award of the lounge catering contract to LSG does not in any way affect the current...
I'm sorry.
Chair.
Did you say 132.13?
14, sorry,
14.
Chair. The next page, yes.
Oh, okay.
So this is Ms. Mshe writing to, amongst others, you, Ms. Kwinana, on the 3rd of September 2015. And it's addressed to the chairperson, but you're copied on it. And she deals under point 1 there with the following. She says, the award of the lounge catering contract to LSG does not in any way affect the current process being undertaken to divest Air Chefs. The lounge service contract represents 4.265% of the Air Chefs' total annual revenue. As per the attached notification to the board, there will be negligible revenue loss for Air Chefs with an estimated 1.8 million net per annum to Air Chefs as per the current CVP and rates related thereto. So she's communicating there to you, as I understand this, that It comprises less than 4.3% of the Air Chefs' total revenue. It was a negligible, on all accounts, part of the Air Chefs' revenue, and only it was going to go to a third-party supplier. So it was not going to close down because this contract was going to LSG Sky Chefs, was it?
I also do not trust that.
You don't
Sorry?
trust that?
Yes. I also do not trust, that is Ms. Mshe's submission, which I do not trust. Chair.
Do you not accept what she says, namely that the revenue that Air Chefs would lose by reason of the fact that this service would be given to somebody else was less than 4.3%? Do you not accept that?
I would have to audit, Chair, whatever Ms. Mshe is saying. I don't trust that.
Okay. As you sit there, you don't know whether it's true or not.
Yes, Chair.
Yes. Do you have a reason not to accept it?
It's because, Chair, as I have said, she has suppressed a lot of evidence.
Okay. But she would have written this email to you at a certain time. I would have imagined that if you saw this and you didn't trust it, you would have checked and to see whether her figure was correct. Did you do that?
Chair, that email was inconsequential. The reason being that a tender had gone out and we had already heard about this thing in Parliament, and I think we already had got them to cancel it. So basically that email was inconsequential to me.
No, it couldn't have been inconsequential. It preceded your decision to cancel the award. It's your acting chief executive officer writing to the board of SAA because she was drawn over the coals on her evidence after that address in Parliament and told she had to account. And she gave this detailed account on the 3rd of September, preceding the board's decision, which comes on the 28th of September 2015. So I put it to you, Ms. Kwinana, it was nothing less of critical for you to understand it, interrogate it, and make an informed decision on it. What is your response to that?
Chair, Ms. Mshe had already gone out to tender, irregularly so, and therefore...
No, Ms. Kwinana, please. You said this email was inconsequential because you had already, as the board, taken the decision that the award should be cancelled. Now, Ms. Hofmeyer tells you that that's factually not true. This email was before the board made the decision. The question now is, we go back to my question. You got this, you saw this email, you saw that Ms. Mshe was saying the revenue that Air Chefs were going to lose by virtue of this decision to award the contract to somebody else was less than 4.3%. If you didn't agree with it, did you check whether that figure was correct or not? And if it was not, what was the correct figure? Did you check that?
Chair, Ms. Mshe had already gone out to tender.
No,
And had
my
already
question is,
awarded.
did you check whether what the correct figure was if you did not trust this figure? That's my question.
No, Chair, I did not check it.
Why did you not, if you
It's
did not
because-
trust it?
It's because I don't even trust whatever he said after she awarded the contract to a foreign company.
But that's precisely the reason why you should check if you don't trust her. If you trusted her, you didn't have to check. But if you didn't trust her, as you say you didn't, that's all the more reason why you should check whether she has got the figure right.
Chair, she had already awarded the tender irregularly so.
But you are about to reverse that if you were not satisfied with her motivation. Now, Why didn't you check if you didn't trust this figure?
Chair, I did not see any reason for me to check. Really, there was no reason for me to check.
Is the position that it didn't matter what she said
It
to
really-
you were not interested, you were simply going to reverse her decision, the decision? Is that what you are saying?
Chair, what I said is the fact that Ms. Mshe preferred a foreign company at the expense of a local company, at the expense of 100% owned subsidiary company. I lost confidence in her, unfortunately.
For that reason, you were not interested in whatever motivation she put before you. Is that right?
Chair, I have seen Ms. Mshe suppressing evidence in this important.
Ms. Kwinana,
commission
I'm
of
asking you a
yours.
very simple question. Did you not care whatever motivation Ms. Mshe placed before you in order before you could take the decision whether to reverse the decision or not? Did you not care whatever she said?
She would write, Chair, the motivation according to her. She would write the motivation according to her.
I think it's the
The
third.
fact that,
Ms. Kwinana, I think it's the third time I'm asking you this question. I'm going to ask you for the fourth time, and it is the last time. Is the position that you didn't care whatever motivation Ms. Mshe placed before you, you were not interested in her motivation?
not after I felt that she has betrayed the country the way she did.
Okay, the answer is you were not interested. Ms. Hofmeyer, continue.
Your evidence was you didn't trust her after she'd preferred a foreign company over a local subsidiary. Is that correct?
Yeah.
She didn't prefer a foreign company over a local subsidiary. An entire tender process was run in which Air Chefs was a competing tenderer. Did you know that?
That was even wrong, Chair.
No, the
Why
question is,
would-
did you know that Air Chefs competed in the tender?
That was not even supposed to happen like that, Chair.
No, Ms. Kwinana, the question is, did you know that or not?
Chair, I'm not going to answer yes or no, but I am.
But you either knew or you didn't know. Or is the position that you don't know whether you knew?
Chair, that tender did not go to the board, and therefore I didn't know that there was a tender going on.
Okay, all right.
Well, she told you in her notes in September and back in August.
Chair,
that
September,
she'd gone
that tender was
Ms.
already
Kwinana,
awarded.
wait until
That
the
tender
question
was
is
already
complete,
awarded.
please. Wait until the question is complete.
Sorry, Chair.
The reason why you end up answering questions that have not been asked is because you don't listen when a question is being asked, or you interrupt Ms. Hofmeyer before she completes her question. Just listen carefully, let her finish her question, and then you can answer.
Sorry, Chair.
You see, Ms. Kwinana, you're absolutely right. The board was not notified before the process. That's because it fell within the delegated authority of structures below the board. What happened is you attended Parliament on the 2nd of September. This issue was raised, and then the CEO was called to account for what had happened, because there was an allegation that this was somehow irregular because it had gone to a foreign company, right? What she does is she then responds to you and she tells you about the tender process that was run. You confirmed having read her emails, is that correct?
Yes, Chair.
And what she said there is the following. I'm now back at page 132.12, paragraph 6. She says, as per the board notification of 20 August 2015. I understand you didn't trust that document. I mean, she repeatedly refers to the memorandum that she's already provided in these emails. I suggest to you, if there was any ambiguity about that, somebody would have picked it up. I don't see that in these emails. Nonetheless, she says, as per the board notification on 20 August 2015, responses to the RFP were received from Air Chefs, LSG Sky Chefs, and Donata New Rest. A lawful and duly constituted procurement process was followed, in respect of which all received responses were properly evaluated. In this regard, it must be noted that Air Chefs failed to meet the minimum threshold for evaluation in the tender and was lawfully precluded from proceeding to further stages of evaluation. Ms. Kwinana, I draw that to your attention because you said it's Ms. Mshe who preferred the foreign company. And I put it to you, it was not Ms. Mshe who preferred the foreign company. Air Chefs failed to move past the first stage of a lawfully and procedurally fair process. What is your response to that?
I'm saying, Chair, that tender was irregular for the reasons that I have just mentioned.
Ms.
It was
Ms.
not even
Kwinana,
supposed to go to that stage. It was not even
Ms.
supposed to
Kwinana.
happen, Chair.
Ms. Kwinana, you are being asked a question about what is written here in paragraph 6, namely the reason why Air Chefs did not get the tender, even though it was one of the tenderers, was that it failed to meet a lawful requirement, certain lawful requirements, minimum, basic minimum. That's what is being said to you. Do you accept that that is why HFs did not get the tender, as opposed to saying it was Ms. Mshe who just preferred to give the tender to another company? Do you accept that?
No, Chair.
You don't accept that HFs failed to meet a basic requirement?
Not even that, Chair, even before that.
Yes,
That
let's
stage
talk
was
about
not
this
even
one.
supposed to have been arrived at.
Let's talk about this one. Do you not accept that
No,
HFs
Chair,
failed to
no.
meet this
No,
requirement?
Chair, I don't accept it.
Have you checked whether they did or they did not?
Chair, that tender, to be where it is, was not even supposed to be there.
No.
It
I'm
was
talking
not even
about
supposed to happen.
this requirement.
Why would I check, Chair, something that was irregular, that was not even supposed to happen?
I'm talking about this requirement. Have you checked whether, when Ms. Mshe says HFs failed to meet a basic requirement, whether that's factually true? Did you check that at the time? Have you checked that subsequently?
Chair, my answer is still, why would I check if the process was not even supposed to have happened?
Ms. Kwinana, I'm going to try the best I can to be fair to you as a witness, because I try to be fair to all witnesses. When I evaluate evidence, I need to evaluate, among other things, what type of a witness you were. And if I make a finding that's very adverse to you as a witness, that might have far-reaching implications for you professionally, please take my guidance. Listen to questions, answer those questions. I go back to my question. This, when Ms. Mshe says HFs did not meet a basic requirement, do you know whether she is right or not right, or do you not know?
I don't know, Chair.
Okay, all right. Ms. Hofmeyer?
Thank you. Ms. Kwinana, why do you keep saying LSG Sky Chefs is a foreign company?
It's because our understanding is that LSG Sky Chefs is a subsidiary of Lufthansa. Lufthansa, our understanding, is a German company.
But were you aware at the time that LSG Sky Chefs is a locally incorporated company, paying tax here and purchasing its products and doing its servicing here with local suppliers?
My understanding, Chair, of LSG Sky Chefs is that it is a Lufthansa subsidiary company.
That wasn't my question. I said, were you aware that it's a locally incorporated company that pays tax here and that was deriving its services and products locally? Were you aware of those facts?
Chair, my answer is, what I knew is that LSG Sky Chefs
I'm
is a
sorry, look this side,
subsidiary.
Ms. Kwinana, so I can hear your answer.
Chair. No, I'm saying, Chair, what I knew is that LSG Sky Chefs is a 100% owned subsidiary of Lufthansa. And Lufthansa is a competitor of SAA.
In other words, you were not aware of what she has just put to you. Because
Yes,
the answer
Chair.
is whether you were aware of that. The question
Yes.
is whether you were aware of that.
Yes, Chair. I was not aware. I am now aware. However, my awareness now hasn't changed what I was thinking then.
Yeah.
It hasn't changed at all.
Okay, all right.
So on your reasoning, Swissport South Africa is also a foreign company, correct?
Sorry, Chair.
Yes, Ms. Mbandra?
I don't want to waste time, but if Ms. Hofmeyer is going to make these statements like saying it is paying tax here and there is no evidence of that, how are we supposed to treat that evidence?
Asking whether Ms. Kwinana was aware of certain facts. That's the basis of the question, Chair. I will ask a question. On your reasoning then, Swissport South Africa is a foreign company, correct?
Yes, Chair.
Yes, and you approved more than 1 billion rand going from SAA to a foreign company then, correct?
I did not approve that, Chair.
You did in the resolution of the 14th of March 2016 when you approved the contract for 5 years to Swissport to provide ground handling services which were going to be to the value of more than 1 billion rand.
Chair, let me explain and try to explain maybe for the third time now how this contract happened. I know that, Chair, you are saying I mustn't refer to 2012, but I need to refer to it because the award was made in 2012. And in 2016, we were approving the terms and conditions. The award was done and it followed a proper process. That's number one. And number two, you cannot compare Swissport and Air Chefs. With Swissport, I did talk about the license, and I did talk about the fact that the reason why SAA Technical could not perform the functions that they wanted to perform is because they did not have a license. And therefore, you just cannot compare Swissport and LSG Sky Chefs. You're comparing two different things. That's number one. Number two, I did not award the contract. I was part of the board that approved the terms and conditions.
Ms. Kwinana, I was just pushing, your analysis of LSG Sky Chefs being a foreign company and putting to you isn't Swissport South Africa in the same position. I don't really want to go back to Swissport because we've dealt with that, but you did say something a moment ago that is inconsistent with your evidence earlier, and so in fairness to you, I must put it to you. You tried to justify the award in 2016.
There was no award, Chair, in 2016.
Wait,
The award was in
Ms.
2012.
Kwinana. Ms. Hofmeyer has not finished to put her question to you. Just wait.
Sorry, Chair.
So I understand your evidence. You justified the contract that was given to Swissport in March of 2016 on the basis that a tender process had already been followed in 2012 that was regular. Is that correct?
Yes.
Yes. You see, the problem with that answer, Ms. Kwinana, is that earlier today, you told us that your recollection of the 10th of February 2016 meeting with Swissport was that you were going there to tell them that a proper tender process had to be followed.
Yes.
Do you remember giving that evidence?
Yes.
That is entirely inconsistent with the version you have just given, which is that the tender process had been already taken care of way back in 2012. Do you have a response to that contradiction?
The circumstances, Chair, are different.
I'm sorry?
The circumstances are different.
Well,
You cannot,
Well, this is what Ms. Hofmeyer is saying to you. She's saying, you said earlier that you went to that meeting to tell Swissport that an open tender would have to be followed,
yes,
okay? But she says, when you say now the contract had been awarded in 2012, that would mean a tender process had already been followed. Therefore, you couldn't talk about having to follow a tender process when it had already been followed. That's what she's putting to her. She's saying there is a conflict, a contradiction between these two things that you are saying. What do you say to that?
I'm saying, Chair, Air Chefs is 100% subsidiary of SAA, and Swissport is not a subsidiary of SAA. So basically, that's why I'm saying that tender should not even have happened, the tender of Air Chefs.
Well, let's take it step by step, because I don't understand what you are saying as being an answer to Ms. Hofmeyer's question. Do you accept that there is a contradiction between the two things you have said? Maybe you say there's an explanation for the contradiction, but do you accept that there is a contradiction?
There must be contradictions, Chair, because the
Yes.
circumstances are different.
Okay, so you say there's justification for the contradiction, and what are the circumstances that make it different?
Air Chefs, Chair, is 100% owned subsidiary of SAA, and Air Chefs was formed to cater for SAA. And therefore, if there is something wrong with Air Chefs, that needed to be corrected by SAA. That is point number one. And point,
Corrected in what way?
like as Ms. Mshe was saying, there were complaints in respect of their services. So SAA, as the holding company of Air Chefs, was supposed to correct that instead of going out to tender, because the reason for the formation of Air Chefs is the same as the reason for the formation of SA Technical. So
Well,
that means the services of Air Chefs were mainly made for SAA. So basically, the relationship.
I'm going to interrupt you, Ms. Kwinana, because I don't want us to take too long on something that I don't understand. Do you accept that if the tender process had been followed in 2012, there would have been no basis in 2015 for you to say there's going to be an open tender process on the same thing?
That's why, Chair.
No, do you accept that there would have been no basis for you to say that?
Sorry, Chair, what is it that I accept?
If a tender process had been followed in 2012,
Yes.
do you accept that in 2015, and if it was the same thing, there would have been no basis for you to say this must go to an open tender in 2015, because open tender had already been followed?
Yes, Chair, there would be no basis for it to
Yes.
go on open tender.
So why did you say that?
That would depend, Chair, when that 2012 tender would expire. And therefore, if that tender would expire now, then that would have to go out to tender.
Yes, but in this case, so why did you say it would have to go to open tender? Is it because it had expired?
Yes, Chair, when we looked at 2012 and we are now in 2016, I think that was a 5-year tender, then it would have to go out to tender.
Well, from 2012 to 2015 is not 5 years, Ms.
To 2016,
Kwinana,
Chair.
to even 2016.
Yes, but remember,
And
Chair,
you know the numbers, you are a chartered accountant.
remember, Chair, the tender process takes long. And therefore, if the 2012, 13, 14, 15, 16, then the other 6 months of the year would have to be used for the tender.
Ms. Hofmeyer.
Chair, I think it's important just to record at this point that we will likely argue in due course that Ms. Kwinana's evidence today is evasive. There have been numerous occasions on which simple questions have been put to her and the answers are not short of evasive. Ms. Kwinana, this question has nothing to do with air chefs. It's about a contradiction in the evidence you've given today explaining the Swissport agreement. So I do need to say that. Do you have anything in response to the submission that your evidence today is evasive?
Well, Chair, it is evasive to you, but I don't see it as being evasive to me.
Thank you.
Yes, Ms. Mandra.
Chair, maybe I need to respond to that kind of argument that Ms. Hofmeyer wants to put.
No, you don't respond to argument now.
No,
you
no.
can deal with the argument later. The reason why she has to put that to her is to be fair to her. But you can later on present argument that says Ms. Hofmeyer's submission in this regard is wrong and has no basis and is not justified by the answers that Ms. Kwinana has given. But that's for later, not now.
No, thank you, Chair. I'm not responding to the argument. I'm just responding to something.
Is that?
Yes. I think, Chair, you will recall that just before we took the break, there was a confusion about a question. And then I said, if we can seek clarification. Chair, you agreed that we can seek clarification. What is confusing this witness? And I'm just advising Ms. Hofmeyer that in future she can be careful. What she does, she takes one line of questioning and then she jumps. Like, for instance, there was a time here when we were referred to an affidavit. I battled to find the affidavit. There was no affidavit. It was actually an email. And then secondly, she moved to the issue of the auditor. I think it's Mr. Motulwe. And then when we're still listening to what is going to happen to this auditor, she jumps. So what I'm trying to say is the witness is not being evasive, but she is being jumped over.
Well, you are presenting argument on whether she's being evasive or not, Ms. Mandra. I said the time is not now for that. It is for later. Okay, let's proceed, Ms. Hofmeyer.
Thank you, Chair. I would just like to conclude the air chefs aspect. We've been looking at that chain of emails, Ms. Kwinana, and we were at the point where the Chair was questioning whether you'd ever taken up the issues that you regarded as lies in Ms. Mshe's submission, and I understand you to have said you didn't, for example, go and check the 4.265%. Is that right?
You know, Ms. Mshe's lies. They start
Look this
from
side,
that
Ms.
issuing
Kwinana,
of
so
the
I can
tender.
hear. Look this
Sorry,
side so I
Chair.
can hear what you're saying.
I'm saying, Chair, Ms. Mshe's lies start from
Ms. Kwinana,
that issuing of the
that's
tender.
that's not the answer to the question. Ms. Hofmeyer is asking you to confirm whether her recollection of what you said is correct. So you need to say, yes, your recollection is correct, or no, it is not correct.
The question was you didn't go and check the 4.265%.
I did not have to.
Yes. You did respond to Ms. Kwinana, though. to Ms. Mshe's email, in which she'd referenced the 4.265%, in which she told you that the company was a local South African company, in which she told you that people were going to be retained. And you did that on the basis that she'd committed treason. Do you remember that?
Yes.
And you wanted her to be investigated by the SIU. Do you remember that?
I still do, Chair.
You still do, right. I guess consistency is a virtue. Ms. Kwinana, this must have been a very difficult time at the board. You had no trust in your acting CEO, is that correct?
Yes, Chair.
You believed that she was lying to you, is that correct?
Yes, Chair.
Did you go back to her and say, give me the nuts and bolts of the 4.265% that you put in your email?
She did not even have to start there, Chair.
No,
She
my
would
question,
have
Ms.
to
Kwinana,
start-
is did you go back to her and say, give me evidence of the 4.265%?
She would have to start from the evidence that Chefs was producing.
Ms.
some
Kwinana,
quality stuff.
Ms. Kwinana, the question is, did you ask her to give you evidence supporting the figure that she put in? Yes or no? Did you ask her for the evidence or
Chair-
substantiation?
Chair, the answer cannot be yes or no.
But it has to be, or if it's not yes or no, it can be, I can't remember whether I asked her or not.
No, but still, it can't be that, Chair.
Why can it
Because
not be?
the reason, Chair, why it can be any of those
Why?
is because I said from the beginning that this was not even supposed to go out to tender.
But
And
that's
therefore,
not, that's,
any process
Kwinana,
after that.
Ms. Kwinana,
Chair.
that's not what the evidence leader wants to know. Please stop trying to give the evidence leader, trying to give me what she has not asked. She is asking you a very simple question. When you read the memo from Ms. Mshe, where she said the revenue that Air Chefs were going to lose if this contract, this business was given to somebody else was less than 4.3%, did you ask her either to give you evidence to prove that or any substantiation?
Chair, I am not going to say yes or no. I'm going to say the process was flawed from the beginning.
So do you know whether you did ask her or not?
Chair, the process was flawed from the beginning.
Ms. Kwinana, I don't know how I can explain this to you. You are not doing a service to yourself. You are not doing justice to yourself. You are a professional. You are a chartered accountant. Clients out there trust that you can do your work as a chartered accountant properly. I don't know how many times I've explained simple things and tried, in order to be fair to you, to say, please, just answer the questions that are being asked. Now, you can't tell me whether you know or you don't know whether you asked Ms. Mshe to substantiate her figure or to give you evidence. You keep on wanting to tell me something I did not ask. It's not going to be good for you as a witness. And if I make an adverse finding against you as a witness, it could have far-reaching implications for you professionally. So I'm asking you again, please just listen to questions. Try and answer the question. If you don't know, say, I don't know, it's okay. If Ms. Hofmeyer accepts that you are genuine when you say you don't know, she won't bother you to challenge that. But if she thinks you are not being genuine, she will ask you further. But for your own sake, please, just listen to questions, try and answer the questions that are being asked. Don't tell me something that you think I want to know, which has not been asked. When I want to know that, I will ask you. Ms. Hofmeyer will ask you. Okay, Ms. Hofmeyer, continue.
Thank you, Chair. Ms. Kwinana, did you consider the advice that had been put together by the highly qualified lawyers in the legal department of SAA about this award?
Yes, Chair.
You did. Did you notice in that advice that they warned that if you were to reverse the award of the tender, that would likely be invalid and not in compliance with the Promotion of Administrative Justice Act?
Chair, from Cape Town, I asked Ms. Fikelepi if the award letter has been sent to Sky Chefs. And she said no, that has not been sent to Sky Chefs. So that also gave me some comfort that SAA is not going to incur unnecessary or be exposed to unnecessary litigation.
So can I just be clear? Your evidence now is that Ms. Fikelepi told you the letter of award had not been sent. Is that right?
Yes, Chair.
Why did you then refer to cancelling the award in your own email?
Cancelling the decision to award. The award was already made. The letter was not yet sent.
Well, that is not true factually. We'll get the letter shortly. But I would just like to focus on the lawyer's advice, right? Because the lawyer's advice that came to you and you said you read says this process was lawful and procedurally fair, and if the board now concludes to cancel it, then there is a risk
saying anything?
that there will be possible legal action and financial
Ms.
exposure.
Hofmeyer.
Oh, sorry, Chair.
Sorry, Chair, Ms. Hofmeyer has just made a statement that it is not true that the award letter, according to the testimony of Mrs. Kwinana, had gone out. Can she please give that evidence?
Wait, Ms. Mbanjwa, she has not finished. You interrupt while she is busy with her question. Just wait.
Chair, I don't want to offend you. She has
Please.
left that question.
Please, she hasn't finished. Give her time. It might not be now, it might be later. Just give her time to deal with to question your client the way she sees fit. And at a certain stage, if she hasn't referred to that and it's important, you can raise that. But
Thank you.
she was still in the middle of her question.
So the legal advice from the highly qualified lawyers in the SAA legal department was that if you were to cancel the award to LSG Sky Chefs, that would likely result in possible legal action and financial exposure to SAA. Were you aware of that at the time?
Yes, Chair.
Yes. And why would you not persuaded by that?
As I said, Chair, I asked Ms. Fikelepi if the award letter has been given, and the answer was no. And in terms of litigation and financial loss, I think I did address that before, because also if chefs was going to close, as I understand, that would also result in financial losses anyway.
Chair, or let me ask first, sorry, Ms. Kwinana, do you know that LSG Sky Chefs did sue SAA arising from this cancellation?
Assisted by Ms. Mshe.
No, that's not the question.
Do you know whether they sued or not, Ms. Kwinana?
The time I left SAA, they had not yet sued.
But do you know whether they...
That's why I'm saying,
Do you know
or
whether
maybe
they...
let me say most probably.
Do you know whether they sued, whether before you left SAA or after?
They did not sue when I was at SAA.
Do you know as you sit there
No, I
whether
don't know.
they sued or not?
No, I don't know, Chair.
Okay.
And so you said you've called her from Cape Town. Is that a reference to when you were at Parliament?
Yes, Chair.
And that was on the 2nd of September 2015.
Yes, Chair.
Well, the letter of award was signed on the 21st of August 2015. So Ms. Fikelepi was just lying to you that a letter had gone out. Is that right?
It may have been signed, Chair, but not submitted to LSG.
That's interesting because LSG Sky Chefs own particulars of claim in the claim that they brought against SAA refers to that letter on the 21st of August 2015. How do you know, Ms. Kwinana, that it wasn't sent to them?
I'm saying it may have been signed, but not yet sent to them.
But it's attached to their own particulars of claim.
What is attached to the particulars of claim? I have
Well,
The
may-
letter of the 21st of August 2015.
Maybe, Ms. Hofmeyr, just to be sure that Ms. Kwinana is on the same page,
Certainly.
explain the particulars of claim to her.
Right. So when LSG Sky Chefs sued SAA, I accept after you left SAA, arising from the cancellation of this very award to it, they sue by preparing a document called a particulars of claim. So they prepare it, right? And one of the documents attached to their particulars of claim is the award letter itself, dated the 21st of August 2015. So I cannot understand, in the light of that, your evidence that they hadn't received it.
Chair, it may happen, and I was saying most probable. That letter may have been hand-delivered by either Ms. Mshe or Dr. Dawa to LSG Sky Chefs and assisted LSG Sky Chef to sue as chefs.
You don't know that as a fact, that's your speculation, is that right?
It's
Sorry,
most
Chair.
probable.
You are not testifying about something you have personal knowledge of how the letter may have reached them. Is that correct? You are just speculating. Is that correct?
I'm just speculating, Chair, and I'm saying, and
Yeah.
I have carefully selected the word most probable, rather than saying possible.
Ms. Mbanjwa, what do you?
Yes, Chair. There is also an element of difficulty in the manner the question is posed, because what Ms. Hofmeyr is saying, she is saying that this letter is attached.
Why can't that be dealt with in re-examination, Ms. Mbanjwa?
No, Chair, it's to assist in the phrasing of the question, because the fact that something is attached to the papers does not mean that.
Yeah,
these
but you
people
can
are saying-
deal with that either in argument or in
But she makes
re-examination.
conclusions, Chair. This is what defeats me, because she says
No,
they received it,
no,
but
there
she
is no
doesn't read the
confusion.
paragraph.
There is no confusion.
Well, there is
What?
to me, Chair.
There is no confusion. Let's go ahead.
You see, the problem I have with your most recent answer, Ms. Kwinana, is in the advice from the lawyers of SAA that you have confirmed in your evidence moments ago you did receive and read. You are told that the letter was communicated to LSG Sky Chefs.
Chair, I called Ms. Fikelepi, and Ms. Fikelepi said the award letter had not yet
Well,
been sent.
Ms. Kwinana, a few days later, on the 7th of September, because remember this alleged conversation took place on the 2nd.
Maybe
On the
Ms.
7th
Hofmeyr,
of
I'm sorry,
September.
Ms. Hofmeyr. What of course would be true is if Ms. Kwinana says, I don't know as a fact whether the letter had been sent out or not, but I was told by Ms. Fikelepi that it had not been sent out, and I acted on the belief that that was factually true. Is that what you are saying?
Thank you, Chair, 100%.
Sorry?
Thank you, Chair, 100%.
Please, Ms. Mbanjwa, hang on. That's what you are saying.
Yes, Chair.
Okay, you don't know whether it had gone out or not, but Ms. Fikelepi had said to you it had not gone out, and you believed her.
Yes, Chair.
Okay, all right.
But 5 days later, in the submission to the board by the legal department of SAA, you were told it had gone out. Did you not? Well, you told us you did read this document. So how could you hold on to what you were told on a conversation 5 days previously when the written document that is submitted to the board tells you it was communicated to LSG Sky Chefs?
2nd of September, Chair.
I'm sorry, just repeat.
2nd of September, Chair. Ms. Fikelepi is telling me that the letter hasn't been sent. And
Yes.
then 5 days later,
On the 7th, she tells you it has. It's gone out. And the 7th of September is before you make your decision. Remember, we got into this debate, Ms. Kwinana, because you said you weren't worried about lawyers, you weren't worried about LSG Sky Chefs suing SAA because you were satisfied that the award letter had not gone out. Do you remember giving that evidence?
Chair, 2nd of September, Ms. Fikelepi is saying
Hang on,
the
hang
award
on, hang on.
letter.
Start by saying, confirming, do you remember giving that evidence? Start by saying, yes, I do remember, or no, I don't remember.
I do remember.
Okay, all right. Then let's take it from there.
Thank
But
you.
now, Chair.
So on,
But now, Chair,
Yeah.
2nd of September, Ms. Fikelepi is saying the award letter has not gone out. 5th of September, the award letter has gone out. So it may have gone out between the 2nd of September and the 5th of September.
Yes, but Ms. Hofmeyer's question is, to you is, if you made your decision as the board on the basis of what Ms. Fikelepi told you on the 2nd of September, without having been given something in writing, which you were given on the 5th of September, saying, no, actually the letter did go out, maybe one could understand. But her question is, now you have something even in writing after the 2nd of September, confirming that the letter awarding the contract has gone out. So how can you still cling to what you were told telephonically on the 2nd when there is now something in writing, black and white, saying that letter had gone out? That's the question she put to you.
You know, Chair, if the information on the 2nd of September is saying the letter hasn't gone out, and then on the 7th of September, the letter has gone out, that means Toli has fast-tracked that letter.
Sorry, that means?
That means Ms. Mshe made sure that that letter is sent out to LSG Sky Chefs.
But you are not answering my question, Ms. Kwinana, which is Ms. Hofmeyer's question. She says to you, when you take the decision that you took as a board, you had the benefit of this email or letter of the 5th of September, which in black and white was telling you that the letter had been sent out. How do you explain your conduct in clinging to a telephonic advice that was given on the 2nd of September? Because one would have expected that now that you have been given something in writing, you would attach more weight to that.
Chair, this contract, as I was saying, as I have been putting it, maybe for the past 3 hours.
No, don't tell me what you have told me for the past 3 hours. Do you have an explanation or do you not have an explanation of why you would prefer to cling to a verbal advice that you were given on the 2nd of September, when on the 5th of September you are given something in writing that says that letter did go out. Do you have an explanation for that, or do you not have?
I have an explanation, Chair.
What is the explanation?
The award, in fact, as I said, starting from the fact that there was a tender competing against chefs, was irregular on its own.
Okay, so it's back to what you said earlier. Ms.
Yes,
Hofmeyer?
Thank you. Just so that we do have it for record purposes, I don't think it's
Yes.
necessary to go there. The paragraph in the legal submission that you indicated you did read at the time is at DD 19, the bundle we've been in, at page 132.5. Chair, it's one of those unfortunate situations where the numbering goes to the other side of the page because it is printed in landscape rather than portrait. But you'll see there at paragraph 2.5 on page 132.5. We're at page 132.5 in Exhibit DD 19.
Oh, hey, will you tell them to please do another one, because you
know.
can't see these,
I know.
these numbers.
It's terrible, Chair. We will
Yeah.
do so.
Okay, all right, 132.5.
Yes, and if you just go there to paragraph 2.5, this is the legal department confirming that LSG emerged the preferred bidder and were recommended for appointment by the CFST, Annexure C. On 14 August 2015, the BAC adjudicated on the CFST's recommendation and supported it and further recommended LSG's appointment to the acting CEO, Annex D. On 19 August 2015, the CEO approved the appointment of LSG as per her DOA, Annexure E. Pursuant to the CEO's approval, a letter of award dated 21 August 2015 was communicated to LSG, Annex F. I don't actually have that annexure attached here. It might have just been left off, but we can certainly source it if necessary. But the point of the matter is the legal department tells you, Ms. Kwinana, as a member of the board, that the letter of award has gone out. They confirmed that on the 7th of September. They warn you that there are likely litigation risks if this award is cancelled. They indicate that the cancellation would likely be unlawful, and nonetheless, you decide to cancel it.
And they say in this paragraph 2.5 that she has just read, that letter that went out to LSG was dated 21 August 2015, and on the 26th of August 2015, there was what they refer to as a kick-off meeting, where a project plan, a kick-off meeting was held with LSG, where a project plan was developed and adopted by SAA and LSG to ensure a successful opening of the lounge on 29 September 2015, which suggests that about a week before you went to Parliament, they are saying LSG had already been given the letter. Not only that, but a meeting had been held with them to say, let's talk about a project plan because the lounge must be opened on the 29th September 2015. That's what that paragraph says.
Chair, I am not aware of that. What I knew was that the award letter had not yet been given, and what I knew, they are also talking about the delegation.
What you were told rather than what you knew, isn't it?
Yes.
What you were told.
Yes, what I was told. And they are talking about the delegation of authority. And as I said, chefs is a major component, is an important component of SAA.
Yeah,
That
but
was
the
supposed to be
delegation of
approved.
authority is
That-
a side issue for purposes of Ms. Hofmeyer's question.
It's not a side.
What's important for her question is whether LSG had received the notification that they had been awarded.
I was told to Chair that the
That they have been-
notification has not yet been.
Okay.
But your evidence was you received this memorandum and you did read it, correct?
Yes, Chair.
So how did you miss this?
How did I miss what?
The fact that you were now being told that it had been sent out?
On 2nd of September.
No,
please,
how did you miss it?
Okay, let me assist Ms. Kwinana.
Chair.
As I understand the position, you have confirmed that the memorandum, paragraph 2.5 of which we read a few minutes
Sorry,
ago.
what page is that?
132.5.
Sorry, Chair, to interrupt. I don't know if I'm at the correct page, because on DD 19, 132.4, is that what has been read out?
132.5.
Yes.
Yes, but that document is addressed to the Acting Chief Executive Officer and to the Chief Procurement Officer. Is that the document that is supposed to have been seen by Mrs. Kwinana?
Yes, she's confirmed she saw it and read it, Ms. Mbanjwa. That's her evidence.
No, I think she must be taken back to that document because it's not addressed to her.
132.5.
Hang on,
Is
Ms.
it this
Ms.
document that starts with 2.3?
Correct. This is the
Where
submission.
does this document start?
It starts at page 132.4.
So this document doesn't go to the board.
No, but you confirmed that you received it because you said that you'd read it a moment ago.
No, she
This
didn't.
document.
Yes, the submission from the legal department. I have your evidence to be that you
No.
had read it.
And Chair,
Ms. Mbanjwa, just hold on, allow the evidence leader and the witness to deal with this, and let's see.
No, I did not read this document. I did not even get it.
You sure about that?
Yes.
but Chair, with your permission, this is what I complain about. When Mrs. Hofmeyer takes a document, takes a document, I've never seen evidence being led like this.
Ms. Mbanjwa,
A witness must be taken to
Ms.
a document
Mbanjwa,
to identify the document.
not all the time.
But this is
Please
what is causing confusion, Chair.
allow Ms. Hofmeyer to do her job the way she believes it should be done. The witness will indicate where she may have misunderstood her question and given a certain answer. And if Ms. Hofmeyer accepts that maybe there was a misunderstanding, she will say so.
But please, Chair, let us be taken to the documents. It's standard in all
Don't,
litigation.
you are not going to dictate to her how to do her job, Ms. Mbanjwa. She's not going to dictate to you how to do your job when you re-examine.
But Chair, it's not her job. There's a witness I'm representing. She's not being taken to the documents.
Please
And
keep
this is what is
quiet, Ms.
causing
Mbanjwa.
confusion.
Please keep quiet. Let's make progress.
So what memorandum from the legal department did you read then?
Maybe what you can do to assist me, Chair,
Yes.
is to take me to the minutes of the board meeting that talk about this.
I want to ask a question before. Your evidence earlier was that you read a memorandum from the legal department. If it is not this memorandum, what memorandum did you read?
Maybe
no
I did
such
not read the
evidence.
memorandum from legal department. Let's say
sorry?
I did not read the memorandum from the legal department.
No, but that's a
because-
different piece of evidence. Are you saying that you did or you didn't? Your previous evidence was you
No,
did.
I didn't.
You didn't. You're now sure about that?
Yes.
When you previously said you did, you were wrong, correct? And then you wanted to go to that board resolution. I'm just going to have to find it, if I may. How will that assist you, Ms. Kwinana?
The reason is because this document is not addressed to the board. And as I said previously,
I think she says if it is suggested that this document was sent to the board, there would be a resolution of the board which refers to this document.
Yes, Chair.
And that's a resolution she would like to
Yes.
be referred to.
yes, Chair.
Yes, I can take you to the resolution at which the decision was made to cancel it. There is no reference to all the documents that preceded it, but I'll take you to it. It's at the same bundle. You have to go now, I think, back a bit in the paging. You have to go to 132.16.3.1.
DD19,
Indeed.
132.
0.16.3.15.
You know, can you please repeat? DD
13, DD19,
132.16.3.1. Those are the minutes of the meeting on the 28th of September 2015.
Yes, Chair. So which paragraph?
And the resolution you'll see at page 15. So it's 132.16.3.15. Yeah, you'll see it at page 15 of 17.
Ms. Hofmeyer, I'm at page 132.16.3.1.
Yes, that's where it starts. And then I was taking Ms. Kwinana to where the resolution is recorded, and that's at page 15. So it's 132.16.3.15.
3.15. Yes, Chair.
You attended this meeting, is that correct?
Yes, Chair.
And your evidence is you may not, are you clear you didn't receive the legal department's memo? Is that your evidence?
Yes, Chair.
Yes. And so you were relying on what Ms. Figalepi had said to you on the 2nd of September about the status of the letter of award, correct?
Yes, Chair.
And you had no reason to doubt what she told you on the 2nd, is that correct?
Yes, Chair.
And you took the decision to cancel the award because you were satisfied if a letter of award had not yet gone out, you wouldn't be in as much risk as if it had. Is that correct?
Yes, Chair.
Thank you. Let's look at the discussion that took place at that meeting. Because, and you saw the resolution. You saw that at page 15. It was resolved that the SAA domestic lounges tender to be retracted and the catering contract to be awarded to Air Chefs without going through the bidding process. Do you see that?
Yes, Chair.
What happens before that in these minutes is the lengthy discussion that took place between the members of the board is recounted. And let's go back a page to page 14 then, 132.16.3.14. And let's go to H at that page. H says the GMLRC. What's the GMLRC?
Legal and risk.
Legal and risk. So who would that be?
Ms. Figalepi.
Ms. Figalepi, the same person who on the 2nd of September when you were at Parliament told you that a letter of award had not gone out. What she told the meeting on the 28th of September, consistent with what is in the memorandum that you now say you didn't see, is she reports the following. At that stage, only a letter of award had been issued and there was no contract in place. She stated that the legal opinion, that's the one we've just been looking at, provided that where a state-owned entity went out on tender, it was considered an administrative action. Therefore, should it want to cancel the tender, it should give the other party an opportunity to be heard, and the reasons for the cancellation should be transparent, competitive, and cost-effective. So, Ms. Kwinana, I put it to you that it was quite clear at that meeting that the letter of award had gone out.
No.
What
Chair,
is your response to that?
This meeting was on the 28th of September, and we were in Parliament on the 2nd of September. So that means by this 28th of September, this letter of award may have gone out, but on the 2nd of September, the letter of award may not have gone out.
No, but that's exactly why I was very careful before we went to this to get clear your thought process. Your thought process was you were accepting cancelling the tender despite the reservations of the legal team, because you were satisfied that the letter of award had not gone out. And I'm putting to you, Ms. Kwinana, that that cannot be so, because you were attending a meeting at which you were told before the decision was made that the letter of award had gone out. What is your response to that?
I still don't understand, Chair, because I am saying on the 2nd of September, I am told that the letter of award
Let me
has
try
not
and,
gone out.
let me try and clarify it to you. You remember that you said that, in effect, I'm not quoting you, that Ms. Figelepi told you on the 2nd of September that the letter of award had not gone out.
Yes, Chair.
You remember that? My understanding of what you were saying was that you were saying that gave you a certain level of comfort to say the decision can be reversed because at least the letter had not gone out. Was my impression correct of what you said? Of why you were making that point?
The decision may be reversed without much damage.
Yes, yeah. What you were saying is it was giving you a certain level of comfort.
Yes, Chair.
Yes. Now, Ms. Hofmeyer is saying to you, when you made the decision as a board that that award should be retracted, you knew, because in that meeting, before the final decision or resolution was made, Ms. Figelepi did say the letter of award had gone out. What she said had not happened was the conclusion of the contract. She is then saying, that is Ms. Hofmeyer, it could not be true that when you made the decision on the date on which it was made, you were influenced by the fact that, by what Ms. Figelepi had told you on the 2nd of September, because that had changed and you knew that. That's what she's saying. What do you say to that?
That's true, Chair.
That's true.
Yes.
Okay, all right.
Thank you. So you weren't then, well, tell me, were you worried then about the litigation risk flowing from the fact that an award letter had gone out?
Yes, Chair.
You were, but you still decided to cancel it, despite the fact that the CFO at that meeting had recorded that he was very worried about the exposure of 85 million rand that SAA could face if the the award was cancelled. Is that correct?
Chair, I was worried about the whole lot of things as I have articulated them here. So litigation was one of them. I was worried there were going to be risks if this is cancelled. There were going to be risks if we did go ahead. So basically, whichever decision that we would have made would have some element of risk.
But the risk that we've looked at that informed your decision related to the retrenchment of employees and the loss of the Air Chefs business. Is that correct?
Yes.
And Ms. Mshe addressed both of those points, but you say you didn't take what she said to be correct. Is that right?
Yes, Chair.
Thank you. And you have subsequently learned that LSG Sky Chefs did sue SAA in relation to this award. Is that correct?
Yes, Chair. Yeah.
Thank you. Chair, I'd then like to move on, if we may.
Assisted by Ms. Mshe.
Ms. Kwinana, you keep making references to the fact that they were assisted by Ms. Mshe. Do you have actual knowledge of that?
No.
You don't, but you feel free in this commission to make claims about which you have no knowledge. Is that correct?
A lot of claims have been made about me, Chair, here.
Miss-
A lot of claims have been made about me here,
Ms.
including you, Chair, Ms. Hoffman.
Ms. Kwinana,
Chair.
when you say assisted by Ms. Mshe, do you realize that what you would be saying is that Ms. Mshe may have acted in a manner that might be seen as unacceptable because she was the acting CEO of SAA. You are saying she was assisting somebody to sue SAA. You realize that?
Yes, Chair.
Now, why would you say such a thing when you have no facts to base that on? Why would you say such a thing about somebody when you don't have facts? Is that the type of person you are? You can just say somebody assisted somebody, put them in a bad light when you don't have facts in a public platform.
I'm saying most probable, Chair.
Yeah, but we have got facts on which to base what you are saying. Even if you say probably, have you got facts? You see, Ms. Kwinana, you are a chartered accountant, you are a professional. There are certain things that even if you suspect, you can't say about people, particularly in a public platform like this, unless you have got facts. It's not responsible to do that. One would expect a professional like you to know that and to act in a responsible manner. Ms. Hoffman?
Thank you, Chair. Chair, I am moving now to a new topic, and we're very close to 6, so it may be
Yes.
appropriate for us to adjourn now.
Yes, I think that's fine. I think we must adjourn till tomorrow.
Thank you.
Maybe we should start a little earlier than normal tomorrow.
Yes,
What, 9:30?
that will be ideal. Thank you, Chair. If it's convenient for Ms. Mbanjwa
Ms.
and Ms.
Mbanjwa, would that be
Kwinana.
fine?
Thank you, Chair. Yes, it is convenient.
Now, would that be fine with you?
That will be fine, Chair.
Okay, all right. So we'll adjourn now, and then tomorrow we'll start at 9:30. We adjourn.
All rise.